like the game's all here.
Oh, look at that. Can you hear us?
Can you hear me?
I can.
Oh, yes.
Yes.
Okay. It started raining already in San Bernardino.
Oh, yeah, it's coming this way.
It's pretty bad right now in San Bernardino.
That's just great. It's gonna stay that way for a while. Yeah, this storm is supposed to drop some serious rain.
Really? Like,
Yeah.
that's serious enough.
Like 2-3 inches.
Really?
Yeah, they were evacuating burn areas in Santa Barbara County. Yeah. It's not like the one this last weekend that was like, oh, a little drizzle, pushing the dust around on the car.
Yeah, that was a joke. I was expecting a little bit of rain. It doesn't say rain here till Monday.
My mom got some snow at her house in Ukaiba. She lives on the northeast part of it up toward Oak Glen. And there was one morning, and her street, which is a pretty steep hill, was covered with snow. And she's like, I'm not going anywhere.
Well, we got snow in Vegas.
Yeah, I heard that.
When we were up there.
I heard about that. That doesn't happen very often.
No.
Hell has frozen over.
It was funny because we were up there and the weather was gorgeous. We were just having a really good stint of weather, and we're seeing all the pictures from home of all the flooding and roads washed out, and people were just freaking out. It's raining in the desert. And it's like, okay, we're fine. Good. I'm glad we're missing it. And it just starts.
Yeah.
And it's like, yeah, but it won't stick. It won't stay. And it did. It actually stayed on the ground and started gathering.
So Flagstaff got like 30-something inches of snow in a day.
Yeah.
More snow than they've ever gotten in a day.
Ridiculous.
Yeah.
And so I was, I forget who I was talking to. It's one of the guys in our firm, probably Pinckney. He's our water guy. I was like, oh man, we could really, California can really use this water.
Yeah, no kidding.
And he's like, well, yeah, too bad we don't have a reservoir to catch it.
Right.
Because again, most of this rain that we're getting is just wasted.
80% of the water goes to the ocean.
It's just wasted.
And the ocean doesn't really need it so much.
Because apparently California has not invested in its water retention system.
And the crazy thing is, they're like letting water out of the reservoirs so that they can have room to put more water in the reservoirs, because more is coming, and then the snowpack in the Sierras are like 150% of normal. So more is coming.
And more is coming.
On the other hand, the waterfalls in Yosemite ought to be really cool this spring.
Oh, yeah. All right.
So how is everybody? Good to see you guys. You all remember who I am?
How you feeling?
Better than I was the last couple of weeks. I timed it perfectly. I got sick on a Tuesday afternoon. And I was telling Professor Noah, I was like, I don't feel so good after lunch. I think I'm going to lay down. And then a couple hours later, I'm like, I'm not getting up.
Now, I have told them the horror that is Crawford from the prosecutor's standpoint, living through it.
Yes.
I told them that
It just kept getting worse
they
and
would
worse.
love to hear a judge's perspective on how.
Okay, so I was a brand new judge in 2005. And Crawford, of course, was like, what, 2003?
Mm-hmm.
So this was all kind of new. And of course, I never heard of freaking Crawford before. I did civil, right? And all of a sudden it's like, oh, Crawford, crap. I'm like talking to the governor's appointment advisor. And, I'm thinking, well, I sort of need to be remotely familiar with this. So anyway, as it turns out, it was the objection to make all the time, every time by criminal defense counsel, because why not, right? Nobody really knew what it meant. And it was like the hot thing. So the objection was like, Crawford. And then after a while, people figured out, oh, well, it doesn't really work quite. It's not like a magic thing to get all the prosecution's evidence thrown out. But for a while, that was the objection. And if you weren't doing your job, if you were a defense lawyer and you didn't say Crawford, every other question. And then gradually the Supreme Court sort of shapes it. Our Supreme Court made some decisions that turned out not to be, well, sorry, I'm kind of overlapping with some sentencing reform that was going on at the same time. Because at the same time, the federal courts had sentencing guidelines, and there was a whole bunch of litigation about, well, if it was something that could increase your sentence under these sentencing guidelines, then it had to be a fact found by the jury or a prior conviction. And so there was a bunch of litigation about that too, and so it all sort of melds itself together in my brain because it was all new to me. But anyway, for a while, it was the objection that you always had to make, right? Everybody's the defense lawyer, Crawford. And then gradually it gets sorted out, and it's like, well, it really, the federal courts kind of sorted out and say, well, it really doesn't mean everything that is an out-of-court statement is covered by Crawford. It's only stuff that, you sort of used to be able to gather when the police were putting together a case back in the 1700s or something. And so gradually they start carving out things. Well, it doesn't include this, and it doesn't include this. And so then it kind of all dies down. And now you don't hear so much about Crawford because everybody sort of knows what the rules are. Every once in a while, there's a serious Crawford issue, and it has to get sorted out. And it always, or almost always, is a 402 hearing at the start of the trial. You get it figured out, and then everybody knows what the rules are. So it was the hot topic, and nobody understood what it meant, so the defense lawyers were always objecting. And then gradually, as it's gotten clarified, and the scope of the problem or the scope of the objection has gotten narrowed down, and so now it's not such a big issue, and it's not often litigated anymore. Was that your experience?
Absolutely. Though, like we said, there's a reason we cover it.
Oh, it is the law.
It is the law. It's still there. It's just that, it's been interpreted by so many other courts, not necessarily the U.S. Supreme Court, who's probably going to stay away from it at this point. That's what we're left with. So,
and there's still some, issues about who can testify to what. There've been some developments recently in expert witness testimony about just because an expert blah 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 says I relied on this and here's what I relied on, that it can't come in. And I think we talked about that you're going to have that the expert can say I read the police report, but if you want to actually get the facts that are in the police report, somebody has to come. Some competent witness has to actually testify to them. You can't just get a whole bunch of hearsay through an expert. That's not Crawford, but it's sort of like Crawford because it's confrontation and cross-examination. Because it used to be your gang expert would get on the witness stand and just like tell all this stuff about the gang and about the defendant and about the defendant's evil friends in the gang. And now, if you want to get that stuff in, you have to actually bring in people who actually know about it, and not just the guy that's the gang expert.
So it was. It became real interesting. I remember I had one case that I'm sure the judge hated me because it was a gang case, and this evidence I wanted in for the truth, and it was gang evidence. So I was bringing the live witnesses in to talk about this evidence. I didn't need in for the truth. I just wanted it in for my expert's opinion. And so we kept a list. Okay, what game, because my game expert relied on all of it in forming his opinion. What was the jury allowed to consider for the truth? What were they only allowed to consider for the expert's opinion? Wink, wink, right? Because they heard it. You couldn't argue it, but once they heard it, right, they were instructed, you're only to consider it as it pertains to the expert's opinion and not for any other reason. Okay, and we know juries follow their instructions.
We presume they do.
But it became that particular case became very messy and got a well-earned conviction that was promptly overturned. There you go. And I heard that just recently, I don't know if they've done it yet or not, but they approved a plea deal with this guy. Oh, gosh dang it. He got elbow when I was done with him. But it was just a mess. Yeah, it really is. So, we only have 2 weeks until midterm. All we've studied is hearsay. So before we get into our Crawford problems, who amongst you was brave enough to step up and say, I'm ready to demonstrate my knowledge on how to analyze a hearsay problem?
Everybody.
You should all have this by
No
now.
problem.
I'm doing parts.
What, by memory or by looking
You can
over?
look at your notes.
Look, you don't have to look me in the eyes, but if I see that you're reading, we're all gonna know you're reading. First step in the analysis, 401, right? And then you go to hearsay rule, which includes what types of things?
Then it's out of court statement, or it doesn't have to be a statement. Offered for the truth of the matter asserted.
And must be a declarative. Yeah. Declarative statement offered for the truth. Let's assume it is. Step 2, you go to
Is it carved out?
exclusions. And you've got 3 exclusions when the witness is on the witness stand. And those 3 are?
Prior consistent ID.
And you know the specific rules underneath those because they're different, right? Prior inconsistent must have been given under oath at a prior proceeding, right? Prior consistent has to be in response to a claim of recent fabrication, and ID is just ID. Then you've got your 5 opposing party statements, and those are?
Present sense impression.
No, not two exceptions.
We're still exclusions.
Sorry.
We're still exclusions,
One is the other party said.
Yeah, the opposing party.
Yeah.
right? And along that same line, did the opposing party, what'd you say?
Conspirator.
Co-conspirators 1,
Other party adopted what somebody else said.
adoptive,
Is it against penal interest?
no,
I see that.
An admission by somebody who gets to talk on behalf of the other party. Right?
authorized
Authorized.
statement, and remember our janitor in the banana peel? Is a statement made by somebody within the scope of their employment, right? Those are your 5 opposing party statements. Okay, so you got 8 exclusions, and you gotta know them so you can check them off and say, these don't apply, these don't apply, these don't apply. Okay, and then you go to, Daniel,
The exceptions.
the exceptions.
And there's a bunch of
There's a bunch of them. But you've got, go ahead.
Question, this is where we might bring in the Crawford analysis if it's a criminal case, hearsay and kind of criminal.
You would, but we'll come back to Crawford at the end, right? At this point, we don't know what kind of case we're dealing with. Could be a civil, we don't know yet. But we go to the exceptions, and remember, we really covered 3 groups of exceptions. Right, those where it doesn't matter if the declarant is available or not. Those where it does matter that the declarants, they have to be deemed unavailable, and then those that deal with written records. Okay, so know those 3 subsections, and then just knock them out, right? And which ones did we cover with regards to the declarant? Doesn't matter if they're available or not. What are those?
Frankincense impression, excited utterance, mental or physical condition, medical record.
Medical records, right? Medical diagnoses,
statements made to a doctor.
Right.
Yeah.
and your written records. What written records did we cover?
Business records, official records.
All right, where you were going, Trish?
Past recollection recorded.
Past recollection recorded, and how do you use it?
You present it to the witness and you say, do you remember this piece of this?
You remember what
Do
you
remember
said or what you-
or what you witnessed or what you.
Yeah.
And if they don't remember, you're asked if they can refresh their memory if they read it.
And
But
if
you
they
can't-
still don't
If
remember
they
it,
still don't remember it, then you read it.
as long as I did remember it when it was recorded and it was accurately recorded.
All right,
Because you can
and
never enter it in evidence. So
who-
You don't,
who
you
gets
don't,
to enter?
The opposing party, adverse party.
Yes. The proponent cannot enter it into evidence, but the adverse party can if they want to.
it gets read in evidence. Right?
Never.
And then the other side can say, here, put this piece of paper.
So the opposing party can admit it into evidence, but the other party can only read it into evidence.
Correct.
Okay.
Correct.
And the reason is, the writing is the substitution for what the witness would say if only he or she could remember. So we're not gonna like make it look better than it would just because it's written down. The jury gets to hear what the witness would have said if he or she could still remember.
And if he or she does remember, they're on the stand and they look at it.
Then you don't get, then the prior statement doesn't come in under past recollection recorded, they just testify.
They just testify, okay.
Because now they have a present recollection and they can testify from the witness.
Are they allowed to straight read it from the paper? or-
No.
Okay, they have to.
They gotta have an independent recollection, they can't just read it.
Okay.
Because if all they're doing is saying, I don't remember now, but this is what it says, then they gotta fit within past recollection recorded. If they look at it and anything, and remember the stupid illustration, right? Anything can refresh a witness's recollection. I show you now a figure of the human brain. Does that remind you of something? You know, it does. And then you can testify to that, right? It doesn't have to have anything to do. Whatever triggers the memory can be used to refresh the memory. But if it's a writing, the other side gets to look at it and can use it to examine the witness. I digress.
And then we have the whole section that deals with if a declarant is unavailable. Okay, and what makes a declarant unavailable?
They're dead, and the,
You can't stick them on the witness stand and make them talk. So they can literally be sitting in the courtroom, right? But if you can't make them get on the witness stand and talk, what are they?
unavailable.
Right.
And go through the list. You gotta know them, or else you're not
They
gonna.
honestly can't remember.
They can't remember.
They refuse to.
They refuse.
They're ill, sick, ill or dead.
They're exercising privilege.
Privilege.
The attorney shows that they've done sufficient effort to contact and they're unable to contact the witness.
Through
or
due
locate.
diligence.
You're hanging out outside the state of California.
And that's pretty much it. But understanding those will help you make sure that you get through that first step, right? If you don't understand what makes them unavailable. And remember, whenever we're talking about an assertion of a privilege or a witness who is refusing to testify, those in and of themselves are insufficient to find them unavailable. What do you need in those two situations? They're saying, I want to assert this privilege, or they're refusing to answer, and you're asking the court to intervene because they won't answer.
Doesn't the judge have to okay that?
Yeah, the court has to act in both instances. The court has to find it's a valid assertion of the privilege, and the court has to order them to answer, and they continue to refuse. Okay, so those two require action by the court, not just the assertion. So when you see the facts and it says, well, I'm not going to answer that because I assert my blah, blah, blah privilege. And it doesn't say anything about the court finding that being a valid assertion and ruling on that, then they're not unavailable at that point. Okay, so make sure that you follow the guidelines of the rules in applying those two unavailability standards. So now you've got them unavailable, right? What exceptions can you use to go with those?
That's the one where the penal interest, maybe it's the
Right.
penal interest.
We got declarations against interest. What else you got?
Dying declarations.
Dying declarations. Do they gotta die in the federal courts?
Yes.
It can only be used in a homicide prosecution in federal court.
But in California, they only have to believe that they're
You
done.
only gotta think. Yeah.
Right. Yeah. And what else you got?
Statement of personal or family hearsay.
Mm-hmm.
That's the one that you said is hardly ever seen.
Yeah,
that's all.
I'm like, I can't remember.
Yeah.
That's all I
And
remember.
then statement offered against a party that wrongfully caused the parents an unavailability. So that's like someone that's threatening someone to not.
Yeah, scared the crap out of the witness.
And
And that actually does come up once in a while.
And what else do you need with regards to these sorts of statements? Right, you gotta have the witness, the declarant is unavailable, and what? There's a plus. Prior
Statement?
opportunity.
Oh, prior.
To cross-examine.
Right, prior opportunity and motive to cross-examine. Okay, and remember with regards to the last one, it is deemed that you waived any opportunity to cross-examine if you are responsible for their unavailability. You don't get to say, well, I didn't, get a chance to cross-examine. I was like, well, you waived it by your wrongdoing. Okay, and what's the odd peculiarity in the federal rules with regards to these hearsay exceptions? Right, before a defendant in a criminal case can assert that he didn't have a prior opportunity to cross-examine, they have to show what? Right, you got a DA who says this person's unavailable, and the judge agrees, yep, I'm gonna find that witness unavailable. Okay, and I'm gonna put their hearsay in, because I've got this exception, and before the defense can say, but I haven't had an opportunity to cross-examine that witness, they have to show what?
That they hadn't voted when we never treated.
Well, that's part of the analysis, but it's unique in the federal rules. In a criminal case, they have to show that they made an effort to secure the witness's attendance as well.
Oh, that's right.
Remember, they have to show that they tried to subpoena this witness and they were unable to. Right? That's not the rule in California, right? You don't get to go into the court and say, well, Your Honor, they can subpoena them if they want to. In the federal court, they have to show before they make that assertion that they made an effort to secure the witness on their own right. And if they have and they've been unable to, then they can say, I didn't get a chance to cross-examine. Now, all of this good stuff in your mind, all of it, that you're going to be able to just flow out on a piece of paper in about 2 weeks. Right? It's just going to flow like magic from your fingertips. You read at the top of this essay. It's a criminal case. Okay? So, first step in a criminal case, still 401, right? Second step in a criminal case, it's probably still the rule, right? Because if you say it's not, if you're able to get in that it's not hearsay, then you're probably still okay, because Crawford only applies to testimonial statements that are hearsay. Remember what we talked about, though. You got to have an end game in your mind before you go down this Crawford road. Because if you jump through all the hoops and you don't have an exception at the end to get it in, it's still not coming in.
Yeah.
Okay? So, you know, you say it's Crawford, all right? Is it declaring unavailable? Yes or no? Right? If they are, move on to the next step. If they're not, just call the witness and you got no Crawford issue. They're not unavailable. Call them, let them cross-examine them. If they're unavailable, then you gotta determine, is the statement testimonial? And what's the rule for testimonial? You gotta go through them all, right? And see which ones the facts give you, right? You've got your Crawford, right? That talks about statements that are made, you know, with expectation that they'll be used at trial, right? Then you got Davis that comes in behind that with the primary purpose test, right? What's the primary purpose of the statement? Are you talking about present events and ongoing threats and what's happened right now in the immediate past? Or are you talking about, you know, something that happened a while ago. And you also look at the level of formality of the interview. Is it a 911 call? Are you talking to the first officer on the scene? Or are you down at the station talking to a detective a couple days later? Right? And then, of course, you got Michigan v. Bryant that expanded that to include, well, is there still an ongoing emergency? Right? And if there is still an ongoing emergency, then statements you make to law enforcement, right, are not testimonial. Right? Because they're given to deal with the ongoing emergency. They're not being given for potential prosecution for use in a court case. And you've got to be able to go through all of those factual rules to see if it's testimonial or not. And it's going to be very fact driven, right? Your analysis has to be fact driven. Who made the statement? Who did they give it to? Under what circumstances? Where were they at? All the things like that. And just kind of remember in the back of your mind, you got Melendez-Diaz that came later that talked about lab testing and lab reports and things like that. But in your determination, is it testimonial? If it is, you gotta go to how they have an opportunity to confront the witness. If it's not testimonial, then Crawford doesn't apply. And if you got a hearsay exception, it can come in. If it is testimonial, the rule of Crawford is the only way it comes in, the only way to cure the unavailability of the declarant is confrontation. Period. That's the main rule of Crawford. If you've got an unavailable declarant and the statement was testimonial, the only way that could possibly come in is if there had been a prior opportunity to confront and cross-examine that witness. Doesn't mean you did. It means you had an opportunity to, and you had a similar motive to. All right? Then you got to talk. I mean, that's going to be there, right? The facts are going to tell you, they had an opportunity to cross-examine or not. Or they're at least going to talk about like the one where it was a civil case and they went into the jail to take a deposition and the defendant was there, right? Did that qualify as an opportunity? Well, that's for you to analyze, right? But at least the facts got to give you something to work with there. And if they don't, then you got to say, we can't determine whether this defendant had a right to cross-examine this witness because there's nothing in the facts that state there they did or they didn't. And then lastly, you look for, did they forfeit their right to confrontation? And that goes in with, have they done something to cause the declarant's unavailability? Right? You jump through all of those hoops. Your very last thing is, do you have an exception? Right? So, do you have an exception? What are they? Everything we just talked about. Right? And once you've gone through all of that, you're going to come under your analysis with 403. Right?
What about the 807 analysis?
Okay, 807 is, look at 807 as another exception. Right? It's not a specific exception, but when it says, do you have an exception, right? Well, yeah, I think 807 applies because by analogy, this is similar to a present sense impression, but it's not really a present sense impression. So here's why I think I can let it in. But remember what the rule says, right? The rule says you don't have an exception that applies. You've given notice to the other side of your intent to use a statement, and you provide the court with justification why it would be unjust, unfair not to allow the statement to come in. So you're going to have that sort of information provided to you in the fact pattern for you to go down that road.
Okay. And one basic thing about Crawford, remember, who's the only party that gets to make a Crawford objection?
Defense.
The defendant. The prosecution never gets to make a Crawford objection. And I know that sounds really simple, but it's easy to forget it when you get jammed up working on an exam or something. So if you find yourself thinking, hey, the prosecution could object under Crawford, just stop.
And if you just think about it, does the prosecution have a right, constitutionally protected right, to confront and cross-examine anybody? No. That's a right that's given to criminal defendants. Okay. All right, let's start knocking some of these problems out, see if we can make some sense to this. I believe we left off on page 426. We were on 1048. I want to jump up there and get their Crawford out of the way early tonight. 426.
I guess I'll do the one.
Okay.
Tender years. Okay, Wilson and Narita is charged with sexually molesting his 4-year-old stepdaughter, Claire. The judge rules without conducting a hearing that 4-year-old children are too young to testify. They can't really understand the duty to tell the truth, and the courtroom experience will be psychologically damaging. Therefore, I rule that Claire is unavailable for the witness. Is the judge's determination proper?
Don't overthink it too much. Is this even asking a hearsay question?
No. This is
No.
having to unavailable.
Yeah, this is talking about unavailability. This is talking about witness competency.
Can the judge just say, I don't care anything about this particular child, four-year-olds can't understand the obligation to tell the truth?
Right.
Or does the judge have to say, this particular 4-year-old doesn't understand? Because if it has to be an individual determination, the judge didn't do that, right?
Right. I mean, the party didn't demonstrate a certain privilege, nor did they what, I'm sorry, I'm forgetting two-prong rule for the unavailability.
Well, it's all of those things that are listed
Right.
and the 804. Right? Are they, is there a privilege? Are they refusing to answer? Are they unable to recall?
Okay.
Are they dead? Are they sick?
Right.
Any of those apply?
None of those apply.
Okay.
Like that.
Let's just, I'll just pose this out to you. Let's say that this judge didn't conduct a hearing, but let's say a judge does conduct a hearing and determines that a witness is incompetent to testify because they're too young and they don't appreciate the duty to tell the truth. Does that make a witness unavailable for hearsay purposes? Is there a catch-all provision in the rule that says witnesses that are competent can be deemed unavailable?
I'm thinking it's 402. So, all right.
If there is, isn't there? Isn't it one that has to do with mental and physical
Well, that's
impairment and inability to
That's the 402, isn't it?
No, that's, right now, focus on 804,
Okay.
okay? I'm sorry,
Maybe.
I believe it's 804. I don't know why my own brain is like, that right? That's 804?
Yeah.
It is, right? Yeah.
So that's what you're saying is where it says cannot be present because death is an existing infirmity, physical illness or mental illness?
Yeah, well, the judge has said this, I'm gonna find this witness unavailable.
Okay.
Well, for hearsay purposes, how do you find somebody unavailable?
So would being too young to comprehend fall under what? Under what? It wouldn't be mental illness.
Well, they're not exempt because of a privilege. They're not refusing to testify. It's not that they say they don't remember, right? It's that they cannot be present or testify because of death or a then existing infirmity, physical illness, or mental illness. Does being too young qualify as a mental illness? Maybe not.
Might be an infirmity, right?
Yeah,
Right.
existing infirmity.
Or is absent and you've been unable to procure their attendance. Right? That's what you have to go to. Right? And that's going to be your analysis.
But notice, this is a determination about this witness, okay? And in our facts, the judge just said, I'm not hearing anything about this 4-year-old. I'm just deciding 4-year-olds can't do it. Do we think that's good enough, or just does the judge need to make an individual determination about this particular kid? I think it's probably the latter.
Yeah.
I don't think you can just have a blanket statement that any witness like this is unavailable.
Right. And if you go back to your, and I'm not saying you would analyze this under an essay portion by using competency rules, but if you looked at that, there was no age requirement in our witness competency
Right.
rules. There was nothing that said you had to be X old to be able to testify, or if you were Y old, you couldn't testify because you were too old. That wasn't part of the analysis.
Yeah.
But for purposes of this question, there's two things that should jump out at you. Number one, did the judge conduct a hearing?
No.
They didn't. And then number two, can he make this determination without a hearing? Right, and your answer is?
The judge's determination was not proper.
Right.
Because he didn't do level 2.
Why isn't it proper for him to do that, to make his own determination of the rule?
Because he didn't.
Because he didn't hold a hearing,
Okay.
right? So nobody got to present evidence, nobody got to talk to the kid, right? And say, you understand the difference between the truth and a lie,
And
and
that's,
you understand it's important for you to tell the truth, all that kind of stuff.
and that's really painful to watch anyway.
Yeah.
Right? So if I, you know the difference between the truth and a lie, right? If I were to tell you my vest is red, is that a truth or a lie? Right? A lie. And then the other side gets up. Well, if I said his vest was not red, is that a truth or a lie? And I go,
I don't know.
the truth? Is it a lie? You can get the kids. It's really sad because lawyers.
And the poor kids often are terrified anyway, because this is a very weird situation. They're not used to like talking in a room full of a lot of strangers and whatever. Anyway, some courts have a therapy dog. San Francisco's got one. Damn it, I wish we had one.
Awesome. With that.
And in the juvenile courts in particular, where the like court dog can be brought to the courtroom and like sit, depending on the size of the dog and the size of the kid, sit in the kid's lap or next to the kid to help calm down and, make them feel comfortable in talking in court and stuff. And then of course you get into an argument about, hey, the witness isn't supposed to have, whatever. Anyway. But that can be really helpful if you're the one trying to offer the evidence from the kid. As a practical matter, try to get the kid to come to the courthouse before the day that they're going to testify. Take them into the courtroom, show them where they're going to sit, talk to them about who all the participants are. This is the bailiff. He keeps everybody safe. That's the court clerk. He or she writes everything down that goes on, and all that, so that when the kid comes back to court, when they're actually going to testify or might testify, they're a little bit comfortable with what's going on. And if you're cross-examining the poor kid, that's a really fun assignment, because you can't beat up on the kid, right? I mean, you have to be kind of nice to him, but at the same time, you want to convince the judicial officer that they really aren't competent to testify.
And let me tell you, it's been, as a practical matter, it's been my experience that courts and court staff are always very accommodating when you want to do something like this. But should you go down the criminal defense path as a career, the good criminal defense attorneys talk to the victim beforehand as well. They introduce themselves beforehand. They tell them, here's who I am. My name's Joe. I'm going to be asking you some questions too. And it really makes the process go a lot smoother. The bad defense attorneys don't care, don't bother, and go after a kid anyway. And juries hate you for that. Even if you actually score points, you're not scoring points.
Yeah.
So the good ones, ask. Hey, can you sit up? I want to meet the victim too and introduce myself before they testify. And the good DAs who actually care about the kid will say, absolutely, let's do it. The bad DAs that are thinking, well, I don't want the kid bonding with you. They're gonna, So if you get a case like that and you're a defense attorney, ask. And if the DA says no, ask the judge.
Yeah.
And the judge
is always going to let you do that.
Okay.
It may put some limits on it, right? It may, have a DA investigator there while you talk to them or whatever. Because, you don't have a right to talk to the kid outside the presence of anybody else. But the other thing with this is you have to think about it. Do I really want the kid to testify? In which case, I want the court to find that he or she is competent, because if I can get the kid to tell a story that conflicts with everything that the kid said on another occasion, hey, guess what? That's probably my best outcome as a defense lawyer, because then it's like, well, wait a minute. Which version is the truth, right? And so sometimes you may want to sometimes you want to keep the kid off the witness stand, right? Because they don't have a real good, what do they call it, RCAT? I can never remember what that stands for. But sometimes they don't have a real good statement from the kid. Oftentimes they do, right? Oftentimes the prosecution has a statement that's videotaped where the kid was talking to a trained sexual abuse counselor who helps elicit the story, and the kid tells this really usually heart-wrenching, very compelling story about what their stepfather or grandfather or somebody did to them. But if the prosecution doesn't have that, maybe they don't have the video, they just have like a police officer saying, or the interviewer saying, I talked to the kid and here's what the kid said. You may not want the kid to be found competent, right? You may want to have the kid be unavailable, and then you sort of get the secondhand version through the interviewer or the officer. And but sometimes, or a lot of times, you're going to want to get the kid on the witness stand, and so you sort of work with work with the prosecution to get the kid on the stand if you think you can get the story that contradicts everything that the kid supposedly said before. Because if the jury or the fact finder is like, well, I can't tell which version of the kid's story is true, that's really good for you as a defense lawyer. Anyway, my point is, you gotta think about it, right? You have to go through all your discovery and figure out, in this particular case, here's what my objective is.
Number two.
With Claire having been deemed unavailable to testify at Narita's trial, the prosecution calls Antonia, a child protective services worker who works for the county, to testify to a statement that Claire made to her. Antonia testifies at a foundational mini trial that Claire told her that my dad keeps putting his thing on my PP. Antonia talked to Claire privately at Claire's preschool in response to a call from Claire's teacher, reporting that Claire had been unusually lethargic and non-responsive for a few days. Antonia further testifies in a mini trial that after a few minutes of conversation about the preschool, Antonia asked Claire if anything was wrong. Claire then made a statement about her father. The prosecution offers Claire's statement into evidence under the jurisdiction's 10 years hearsay exception, which applies to statements made by children under the age of 12 describing acts of sexual abuse or neglect. Is Claire's statement testimonial? If so, what are the consequences of it being testimonial? Might the answer to question 2 be different if Claire's statement had been made to her babysitter rather than to a child protective services worker?
Okay, so you see the word testimonial?
Yes.
This is all about Crawford, right?
Right.
So this particular question, if you follow it, has already laid out the analysis for it, right? Declare it's unavailable. Is this statement testimonial? Hint, hint, you gotta talk about whether it's testimonial. And oh, by the way, would it be different if it was made to somebody else? So that should clue you up. There's something about being a CPS worker that's different or potentially different than being a babysitter. Okay, so it's a testimonial.
Okay, so going to her status as a CPS worker, yes, it's likely going to be used later for trial to determine.
CPS workers gather evidence to do stuff.
Right.
Right?
Right.
Like take kids away from parents.
Yes.
In criminal or quasi-criminal proceedings.
What are the consequences of it?
Well, but let's talk about that for a while, because you think it's just like a slam dunk that it's definitely testimonial?
I mean, why else is she?
Okay, but
okay,
who's your declarant?
The Claire.
Right.
You think Claire is telling a CPS worker this happened to me because she's appreciating that, oh, this is going to be used at court to prosecute daddy?
I thought it was under the objective witness reasonable ability to believe this. Isn't it the perspective of Antonia?
No, she's if you think testimonial and you think cop, Antonia's in the position of the cop. She's the one who's receiving the information.
Okay.
Right? So if you're going to go down the analysis that, well, does the declarant think it's reasonable that it'll be used later? That's not Antonia's. Does Antonia think it's going to be used later? Of course she does. Right? But does Claire?
Probably not.
Probably not.
Yeah.
Right? She's probably not talking to the CPS worker about that. Right? So if you go then to Davis, right? What's the primary purpose test? Right? What's the primary purpose for both the witness and giving their statement?
Well,
What's Claire's reason for giving this statement?
well, it's like they call for help for an ongoing.
Well, Claire's, I mean, the teacher noticed that Claire was lethargic and maybe upset. So Claire's purpose is these adults are talking to her.
Right. Well, she opens up, so.
Yeah, she opens up.
She's likely trying to.
Wants it to stop.
Yeah.
She's seeking help. So from Claire's perspective, under Davis, non-testimonial.
Mhm.
What about, because you also have to look at the person who's receiving the information, right? What's Antonia's reason for conducting this interview?
It would be for investigation, wouldn't it?
To see what happened. This isn't like, hey, the police have decided a crime has occurred, or is it? Maybe it is. I don't know. But that's something to think about. Is that CPS worker there to find out what happened, right? Or to gather evidence to prove what happened to convict Dad? So is it like the cop who goes back to the scene a few days after the crime and is, talking to witnesses, gathering evidence, putting the case together? Or is it more likely, I'm just trying to figure out what's going on here? Is there an ongoing emergency, right? Is Dad improperly touching the kid, like at home, right now? Last night, tonight, tomorrow. In which case, it sounds more like you're trying to figure out if there's an emergency or if there's something that needs to get addressed, rather than trying to gather evidence to prove a criminal case. So you've got something to work with, and I contrast that with the teacher, okay? Statements made to the teacher almost certainly aren't going to be testimonial. The teacher's just like, hey, why are you upset, right? The teacher's not trying to put together a criminal case pretty clearly. The teacher's just trying to, is the kid okay? So you've got something to work with, I think, either way with that. Because you could argue it either, if you're the prosecution, you can make a decent argument that, hey, this isn't trying to put together a criminal case. This is trying to figure out, is something going on that needs to be addressed?
So now, I guess I would argue more so, based on the facts, it's an ongoing emergency, plainly call for help.
So maybe not testimonial.
Not testimonial.
But either way, you've got stuff to work with, right? No matter how you come out, you got stuff to work with and stuff to explain. Well, yeah, but there's this, right? So how about the babysitter? Statement made to the babysitter.
Well, it's addressed the fact that her status has changed, or the individual hearing her statement.
Is there any way that's testimonial?
Doesn't seem testimonial.
Is there any way that's testimonial? Anybody? Anybody think that's testimonial? Statement made to the babysitter? She doesn't work for the government. He doesn't work for the government. Has regular contact with the kid. Isn't trying to gather information to put together a criminal case, right?
Yeah, just based on.
So I don't think there's any way that a statement to the babysitter could be testimony. Does anybody think otherwise? And you see why? Does that make sense?
Yeah.
Okay.
Questions on that one? Before we move along?
Well, just for test-taking purposes. So it became like a two-pronged discussion right there, just on the testimony portion of it. Are we supposed to talk about one and the other briefly, and then make a transition moving forward?
The question is it testimony?
Right.
So
Make it.
take a position and explain
and
why.
support it.
Okay.
I say this is testimonial because, right, she works for the government, she went there to investigate, blah, 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 blah. I think it's non-testimonial because she doesn't know the child's been abused, she's just going there to find out why this child is lethargic. And next, what are the consequences of it being testimonial? If it is testimonial, the only thing that cures it is confrontation. So has Dad had an opportunity to cross-examine Claire?
How could he? Judge said she's unavailable.
She hasn't There's nothing in here that says she testified at a prior hearing or deposition or you name it. So he hasn't. Right? So if he hasn't had an opportunity to cross-examine him, does this come in if it's testimonial?
No.
There's no way. There's no way. If it's testimonial, there's no way it comes in. Right? If it's non-testimonial, do you have an exception? Why, yes, I have the tender years hearsay exception that the rule told me about. I mean, that the problem told me about. Okay?
So now I don't have a Crawford problem, why? Not testimonial. And I don't have a hearsay problem, why?
Because
Tender years exception.
All right. 1049. Eager. Just
Tipping point. Thayer is charged with illegally distributing prescription drugs. At trial, undercover government agent Narc identifies Thayer as the person who he saw engaged in the sale of a large quantity of Norcodine pills at the 3rd Avenue underpass. Mark testifies further that he staked out the location where the sale took place based on statements made to Narc on the street to the effect that if you need Norcodine, Thayer is the person you want to see, and his office is the 3rd Avenue underpass. Thayer objects to this portion of Narc's testimony under the Confrontation Clause, should the judge sustain the objections. Okay. So Confrontation Clause applies to
Okay.
statements that are testimonial.
What isn't this?
What-
This is not a hearsay objection, right?
No.
Okay.
So if you need Norcodine, Thayer is the person you want to see. His office is 3rd Avenue underpass. So that would be a testimonial statement because it's not made in an emergency. It's not made to like an authority figure, right?
Made to an undercover cop.
But do they have to know that they're talking to?
I don't know.
what does Crawford say? Right? Crawford says, right, is it being made with an expectation for use at a later trial? Right? Do you believe that the statement that was made to Narc, who we don't know who it is, right? But the person who talked to Narc
Mhm.
made that with the expectation that it was going to be available for use at a later trial,
Ooh, probably not.
right? Is there any sort of formality to this interview, assuming that it even was an interview?
No.
It's two people talking.
Yeah.
Right? Do you gotta know that you're talking to a cop?
Well, I would assume you would, because the statement has to be made in anticipation for a trial, or, right? And if you don't know you're speaking to a cop, then it would be hard to prove that those were your intentions.
On the other hand, it's certainly the cop's intention, right?
Yeah.
So can the cops like trick people into making statements that then deny the defendant a chance to confront and cross-examine because they trick people into making statements?
I mean, I would imagine that'd be an infringement of their confrontation, the rights in the confrontation clause, would it not?
Do your analysis. Right, you got the stuff right there.
Okay.
What's the first thing you do in Crawford?
You see if it's testimonial or not.
Go back one.
If it's barred by the hearsay rule?
Well, the first thing I would analyze under Crawford is your declarant unavailable?
Okay.
Right? Do you know if your declarant's unavailable?
No, we don't even know who the declarant is.
Yeah,
You don't?
it's not facts, but I would
Right.
assume he is.
So that would be your analysis,
Okay.
right? In order for a confrontation clause objection to be overruled, the tenant would have to be unavailable. we don't know whether this person is. Assuming they are, the next step is,
I have a question. Why
Yeah.
would it matter if they're unavailable or not if it's not testimonial?
well, it wouldn't, if it's not testimonial,
So
Crawford
would that
doesn't
be-
apply.
Okay. So would you do that as the first step then?
I wouldn't. I think you want to be consistent in how you analyze it. If you start saying, well, I want to analyze this
This
problem
first,
this
and then-
way and this problem a different way, you're gonna miss something. Right?
Yeah.
And that's why I would make, right, let's just say you jump straight to testimonial. Right? Well, you know what? This is testimonial. And he hasn't had an opportunity to cross-examine it. Right? So I'm gonna say, nope, sustained. Right? Crawford applies, and nowhere in your analysis do you even talk about whether the declarant's unavailable or not. Right? Because you jumped ahead and you went through it. I would be consistent in how you attack it. That way you make sure you hit every problem. Okay? And then you go, is it testimonial?
Here it was.
You think it,
You
you
would
think it is?
argue that it was. The other argument would be, well, it was made to a cop, even though he was an undercover cop, and he.
The whole point of an undercover cop is to gather evidence for what? To prosecute somebody.
Yeah. So in a test, you would just
But
choose a
here,
side.
but then you might say, on the other hand, wait a minute, the cop's gathering evidence to prosecute somebody, you don't even know who somebody is? Well, I guess he sort of does, 'cause
you
the
don't even
guy's-
know who you're talking to.
Because the guy said, so-and-so's selling the drugs down at the 3rd Street underpass. No, well, maybe, I don't know.
You gotta pick a side and argue it.
Yeah.
Personally, I think your better argument is this is not testimonial, right? It is, do you know you're talking to a cop? No. Well, your intent matters as a declarant, and then the cop's intent matters. What is he doing at this point? The crime hasn't even been committed yet.
You're just passing along.
He's trying to gather information about, future crimes. He's not prosecuting anybody yet. But you see that the argument you have both ways.
Mhm.
Okay, assuming it's non-testimonial, do you have a hearsay exception?
Is it hearsay? Is it being offered for the truth or just to explain why the cop went down to the 3rd Street underpass and looked for so-and-so?
It's being offered for the truth.
Is it? Do you give a damn whether the jury believes it's true or not?
I don't know, you just want to.
No, you just want to explain why the cop went down and looked for, whatever the drug dealer's name is.
There.
There.
Yeah, that's why. So I would argue it's not hearsay because it's not being offered for the truth, just to explain what the officer did or didn't do.
But in an essay, would you do that analysis? Would you even get to Crawford?
Well, I don't think the question you asked about hearsay, but we got kind of added to it.
Oh, okay.
I think the question was focused on Crawford.
Yeah, Crawford, okay.
And don't forget, for something like this, a 403 objection. Why is that going to be important? Because if you get to the point where you're going to offer, some unidentified dude saying, go down and look for, Hop selling drugs on the 3rd Street underpass, you have a very good chance of excluding that under 403. Now, you might be able to ask, did you get information from somebody that there might be some illegal activity going on the 3rd Street underpass? Yes. Great. And not get to say what the information was, just to explain, that's why I went down there. But especially for something like this, if you get to, yes, it's non-testimonial, yes, there's a hearsay exception, yes, I can offer it, be thinking 403. Because I at least would be likely to sustain a 403 objection on this.
Do you get it?
Yes.
Okay.
think so.
I don't, the one thing I don't really get is why the intent of the undercover cop matters when you're analyzing whether it's testimonial or not.
Because it's like both sides of the statement, right? You've got the person making the statement and the person who's getting the statement. So if a cop is out gathering information, even if a witness, a declarant, doesn't realize they're talking to a cop, if the police are out gathering information to put a criminal case together against someone, that sounds exactly like the kind of stuff that Justice Scalia was worried about, being able to confront and cross-examine. So that's why both sides of the conversation, intent of both sides of the
Because
conversation.
Justice Scalia was kind of unclear, essentially.
Well.
Well, yeah.
But this rule, what is Honor's talking about goes straight to Davis, right? Davis says part of your analysis is the nature of the questioning, right? The level of formality of the interview. Why are you questioning this witness? I want to find out what happened, which way the bad guy ran, right? Did they have any weapons, as opposed to, hey, can you come down to the station with me? And, you know, now you're in an interview room, we're going to record this. And, you know, and now your questions are, you already know who your suspect is and what they did. And I want to show you some pictures and see if you can ID somebody, right? The nature of that questioning is clearly at this point to gather evidence for a court.
But I'd say even if you've got an undercover cop who's not disclosing that they're a cop, but they're out there actively trying to get information to put together a prosecution against a particular person, you're going to have a Crawford problem. Even if the intent of the person making the statement, well, they'd never talk to the cops if they knew they were doing it. But the cops are like gathering evidence to use, right? And if that's what they're doing, I think you've got a significant Crawford issue.
So I feel like you would a lot of the times have Crawford issues whenever you have an undercover cop situation, in which there's a lot in regards to like drug related charges and
Well,
stuff.
it depends what you're doing, right? What was the name of this problem?
Tipping.
Yeah,
Tipping point. What did the declarant give to NARC?
Tip.
Give him a tip. Right? At this point, does NARC have any evidence against Thayer? Right? Does he, does he have probable cause to arrest him? No. Does he even have a reasonable suspicion to go search him?
Nope.
He doesn't. But let's say NARC's been on Thayer for a month and he's seen buys and locations and deliveries and hand-to-hand. He's seen it.
And they got a
And
wiretap of Thayer's phone.
And he could arrest him, but they're trying to get the big fish, right? They want to get their supplier. And he goes under and he finds the declarant. He says, hey, where can I find Thayer? Thayer's on 3rd Street underpass. That's his office, right? Well, it's still the same statement, but now, why are you asking that? You're asking that because you're building a case against somebody who you could already prosecute, right? So the nature of why you're asking those questions are different. If it's the first time you're asking and you're just trying to, start
Do you know where I can score some, whatever?
Yeah, if you're just trying to get some information and you don't have anything, but if you already got something and they are now a suspect and you're questioning about them, it's different.
Does that make sense?
Yeah, no, it makes sense.
So that's why both sides of the conversation matter.
Well, you're questioning the intent of the cop's question when
Sure.
we're analyzing the statement made to the cop. Not the
And it's
cop's.
Right,
It's
but
it's
that's
combination.
part of the, is it testimonial?
Okay.
Are the police putting together a criminal case against a particular person? Because if that's what they're doing, man, that sure sounds like it's testimonial. that's the kind of stuff that, you know, Justice Scalia would have said, hey, back in the 1700s, the police were like getting witness statements to put the case together, and that's the kind of thing that the Confrontation Clause was designed to prevent. Out-of-court statements being offered to prove somebody's guilty. So context
And
matters.
you really have to look at the intent of the officers, as well as the intent of the declarant, right? Why are you over here? Because you serve functions besides investigation if you're a law enforcement officer.
Right.
And part of what you do is you respond to emergency situations. You respond for cries for help. And you get out there, what's going on? What do you need? Well, every time you go out there and you get a call, oh, somebody's got a gun, oh, I was just robbed, oh, somebody stole my car. When you go out there, arguably, you're investigating a crime because somebody has reported a crime. But the court says, that's too
No,
much.
you're just trying to figure out what the hell
That's
is
too
going on.
much, right? And that's why they started loosening the original structure of Crawford, because it was nothing was coming in. If you talk to a cop at any time, nothing was coming in. And they said, that's not what we want. So let's loosen it up a little bit, and let's look at both sides. Why are you calling the cops? Right? Well, you know what? I'm calling to tell you my boyfriend hit me 2 days ago and gave me this black eye, and I want him arrested. Clearly, your intent is to prosecute somebody and get them in trouble. And that's going to be used in court, as opposed to come help. I
My
just
boyfriend's beating me
got
up right
hurt.
now.
You know, there's
And I don't, or he just left and I don't know when he's coming back, and I'm scared.
So, it seems that we've expanded on this rule for testimonial statements. So, from this fact pattern, one side, their intent is to just provide a tip, while the others trying to get a investigation for a little criminal trial. So we deem this problem, say, testimony.
The way the problem's originally written, I don't think it's testimony.
This is
Because the cop is just trying to find out, basically where can I score some whatever. Doesn't know that the crime's going on, isn't trying to put together a case, is trying to find out where they can do some investigation.
got it. Thank you.
And if you actually, it's funny because I'm just kind of looking at the facts again, something that I think would go to the analysis. Right, Narc testifies further that he staked out the location where the sale took place based on statements made to Narc on the street to the effect that if you need Narcoline, there's a person you want to see in his office is the 3rd Avenue underpass. It doesn't say Narc questioned anybody, right? It says these were statements made to him. That's the quote, statements made to Narc. Doesn't say they were elicited in any way. We're kind of assuming, well, he must have talked to somebody. But if you wanted further analysis for why you think it's non-testimonial, you can say, well, there's no evidence Narc elicited any of this information.
Yeah, Narc was probably just hanging out on a street corner and somebody said, hey, you want to get some,
You look like you need some Narcoline.
yeah, you know where you can get it? And by the way, can I have $20 for the tip? Or you want to get someone, we'll split it? Now that happens.
How about 1050?
I'll do it.
All right.
Jumping in.
Devin Michaels is charged with armed robbery. The prosecutor seeks to offer into evidence a hearsay statement made by Edmund O'Toole stating that O'Toole saw the defendant with loot taken in robbery. Now, assume that O'Toole's statement would be admissible as a matter of hearsay law.
I.e. you have an exception.
Exception, exclusion.
Or,
No.
or an exclusion, or
Whatever,
it's not,
it's
or it's not
admissible.
hearsay.
Do not consider the hearsay implications. Okay.
So if O'Toole is unavailable to testify at Michael's trial, the prosecution could offer her hearsay testimony into evidence under the confrontation clause if, one, O'Toole made the statement while
Let me ask, before you go on, so what is the question asking you?
It's asking you to dismiss the hearsay part of the confrontation clause.
Is it admissible under Crawford?
But is it admissible under Crawford?
Period. So
That's all.
they're already telling you declarant's unavailable, they're
Yeah.
already telling you you've got an
Yeah.
exception. So the only thing you're looking at is testimonial, and it's not talking about any prior testimony. So confrontation, prior opportunity is not gonna be part of your analysis either.
It's just, is it testimony?
Is a testimonial and a whole bunch of
Okay.
options.
Number one.
Number one, O'Toole made the statement while testifying under oath to the grand jury that indicted Michael.
Aha! So it was under oath.
Testimonial.
So. Yes.
Well, darn right. That's exactly what Scalia had in mind.
Right? You are testifying.
Definitely.
What is it? What's a grand jury doing? Gathering evidence to prosecute a criminal case. Yeah, okay. And did defendant get a chance to confront and cross-examine in the grand jury? Nope, because defendants aren't in the grand jury room, right? So that's absolutely a testimony.
Okay.
Sorry.
And is there another type of investigation where there's not, what's another type of, not grand jury, but,
Preliminary hearing?
no, maybe. Preliminary hearing, what about?
Those are the two ways you can get indicted or held to answer to a criminal charge, felony charge.
Okay.
And yes, you do get to confront and cross-examine witnesses, except under Prop 150. Anyway, we digress.
Number two, O'Toole made the statement while testifying at Michael's preliminary hearing.
Aha!
Michael's represented himself in the preliminary hearing, at which time he had a chance to cross-examine O'Toole, but did not. Aha.
Aha! Opportunity to confront and cross-examine?
Yes, but he chose not.
So then what happens?
So it's in.
Darn right. You had the opportunity.
So that's an example of it being waived.
What?
That's an example of it being waived.
No, that's an example.
No,
of
that's an
having
example of the opportunity
Okay.
to confront and cross-examine. Just because you didn't take the opportunity doesn't mean you didn't have it.
Number three, after reading a story about the armed robbery in her local newspaper, O'Toole voluntarily called the police department hotline and recorded a message describing what she had seen. Well, that sounds awfully, well, wait, that could be like a 911 call.
So what's O'Toole trying to do? This is after the crime. It's been reported in the paper.
Right, but it's.
So what's O'Toole doing? Intending to provide information to the police to do what?
To.
Help put the
help
case
assist
together.
in a trial.
Yeah.
Yeah,
And why did the police have a tip line?
for that same.
To help get information to put cases together. Sounded an awful lot like that's testimony.
Yes,
Does that make sense?
yeah, because, when I read it, it's already happened a long time ago.
Because this isn't there's a tip line so that people can call to report crimes the police don't know anything.
Right, like it just
Right?
happened. If it
This
just
is
happened,
this is
then
a,
it's
yeah.
a call.
Then you're calling 911, right?
Or a tip line. I guess.
Or a tip line if you're really, really scared. But here, crime's already been committed, police know about it, it's in the paper.
It's over in the paper. Okay,
So
yes,
probably,
definitely.
both sides here are intending to provide information, collect information to be used for prosecution.
and number four, O'Toole made the statement while testifying for the prosecution in the trial of Michael's co-conspirator Sally Welch.
Ooh, interesting.
Welch was tried separately prior to Michael's, and Welch's lawyer thoroughly cross-examined O'Toole in the earlier trial.
So did our defendant get a chance to confront and cross-examine?
He's testifying. She's testifying at the prosecution trial.
Our guy didn't get to confront and cross-examine, right?
Right.
Wasn't a party to that trial. Is it good enough that somebody else got to confront and cross-examine?
I would think so.
Why not? you think it is?
I think it would be good to have someone else.
Because after all, my right to confront and cross-examine could be exercised by somebody else. Anybody disagree with that?
I disagree.
Yeah. I got the right to confront and cross-examine, thank you very much.
Okay.
So what do we think?
It's,
Did our defendant have the right to confront and cross-examine? Or the opportunity to confront and cross-examine?
Did not have the opportunity.
Does it matter that it's a co-conspirator? No, because we're not talking about an exception to the hearsay rule or an exclusion to the hearsay rule. Right?
Right.
Does everybody see the difference?
That has to be-
Co-conspirator statements made in the course of the conspiracy come in. They're not barred by the hearsay rule, right?
Right, they're one of the exclusions.
So it sounds like, hey, my co-conspirator got to confront and cross-examine, so that ought to be good enough. But it's not,
Okay.
because I got the right to confront and cross-examine. And of course, is a criminal trial testimony a criminal trial testimonial? Anybody?
I think so.
Yeah, that one's kind of, yeah. Okay.
Just before we move too far along, I just want to throw something out there to you guys because there are cases on this that you need to be aware of, right? A lot of police departments have tip lines, right? Where you call and help and it's anonymous and maybe we even give you a reward and all kinds of that. What if it's something like an Amber Alert, right? What
Kids being kidnapped,
you know?
right? You see it on the freeway, your phone.
We all
Wow,
do it.
wow, wow, right?
Yeah.
And you call. I just saw the car. Kid in the back, banging on the window, crying, tears in their eyes.
And it's on Interstate 10 about the 100-mile marker, and they were going eastbound toward Blake.
Well, you already know the crime has been committed, right? Think it's testimonial?
The argument would be, is it like a 911 call or is it testimonial? But
Crime's still going on,
Crime's
right?
still going on, it's ongoing,
Whoever's kidnapped a kid is still kidnapping the kid.
yeah. However, you could also argue because of the Amber Alert, because everyone knows what that means. It actually means that, you actually are making this call, hoping to catch the person. You're seeing the person who's driving.
So it's not trying to get evidence to put together a criminal case. It's trying to catch the dude so the kid gets rescued and saved, right? Which sounds more like,
Ongoing emergency.
Yeah.
Right. Right, so just kind of keep in mind, right, it doesn't even have to be a 911 call, right? Remember what did they do in Bryant? They said the gun's still outstanding. Armed robbery, right? She reads about it, she calls it in and she says, hey, I saw this guy with the loot. I'm calling this tip line. But the gun has not been found. He's armed and dangerous, still at large, right? Does that impact your analysis? It should. Doesn't necessarily change your conclusion, but it should impact your analysis. Okay, when they give you those sorts of facts, they're giving you them for a reason. Okay?
yeah, with our particular question here though, call the tip line after you read about it in the paper. Yeah,
Yeah, that's.
and there's no ongoing
Emergencies.
emergency.
Done.
And what if they tell you that he's armed and dangerous and at large?
Oh.
And you read it 3 days later. He's at large still, armed and dangerous. How long did Brian extend the emergency for?
I thought it was,
Ongoing.
Days.
yeah,
Days they extended it.
right.
So just Like I said, it's probably, if you're calling it tip line, it's probably gonna be testimonial, but if they give you facts like that, he's at large,
Yeah.
make sure you analyze, you take them into your account in your analysis, because they're giving you them for a reason, right? They're not just saying, oh, he's still at large, right? They're giving you them for a reason, and that's to tip you towards a Brian analysis, okay? That doesn't mean your conclusion necessarily changes. It means you got to talk about it, okay? So without that information, you're kind of doing a Davis analysis. Why are you calling? Why are they setting up the tip line for prosecution?
And for a kind of extreme example, suppose you're Ted Kaczynski's brother, right? That dude had shipped a whole bunch of bombs to a lot of different places, manifestos, still going on, right? And Kaczynski's brother calls the cops and says, man, that crazy manifesto sure sounds a hell of a lot like my brother who's holed up in a cabin in Montana, right? Is that testimonial? I don't know, but there's a real good argument that it's an ongoing emergency.
There's a lot to that, right? Do you know he's going to get in trouble and prosecuted?
Yeah. Which is probably why you sat there going, oh, should I call the cops? Should I call the cops? Should I get my little brother in trouble?
So you got to analyze it and make a decision, okay? And if you deem it testimonial, the only cure for that is confrontation. If it's non-testimonial, it comes in. If you have a way to get it in. Okay.
Did we have some more in this question?
No, that's it.
Okay.
All right, we have a few more problems to do. Why don't we take a break real quick, and then we'll come back and knock out. We got 3 more, and don't think we're forgetting about you. Don't even think about it.
But-
She's like, oh, yeah.
But I think that last bit about the co-conspirators trial, the point of that, or a point of that, was that you separated the hearsay rule about getting statements of co-conspirators in from the confrontation right. Nobody gets to do your confrontation and cross-examination but you. It doesn't matter how aligned the interests are of the guy that went to trial. In a criminal context, you get to confront and cross-examine if you got the right.
Okay, now keep in mind, we're talking criminal here.
Yes.
But remember, we did that civil case, and don't get confused with that. Remember where that bus was in the accident and the passenger sued and the witness testified, right? And then another suit, another passenger sued, and the witness is no longer available, right? Did the bus line have an opportunity to examine, and did they have a similar motive to examine, right? And there was a separate analysis there. And in that case, remember, the question was, the witness had gotten sick, right? And the defense attorney said, well, I'm not going to question him because we'll stipulate to these facts. Remember? So there is that analysis out there. It's not Crawford, it's not in a criminal case, but there is an analysis that you will do for your declarations against interest and the like, where having a prior opportunity and similar motive can get the statement in.
But don't get that confused with Crawford,
Okay?
because that's not Crawford.
All right. Break. Ready?
Yeah, one of my favorite evidentiary rulings that I won was getting testimony of the guy that did the tort excluded in case B when the testimony was given in deposition in case A, and I was sitting in the room, and I was representing the same defendant and had the same opportunity to count, right? But the way that evidence code talks about use of depositions, they could use it all they wanted in case A, but they couldn't use it in case B. And
they were probably kicking themselves like,
well, I know exactly what happened. The lawyers on the two cases were talking with each other, and they just assumed that they could use it in
right.
case B, right? And I'm like, hey.
Not so fast.
And Doug Miller, they might object. It was when he was a trial judge.
Thank you, Ryan.
Well, yeah, that was still a lawyer. Oh, man, that was.
Oh, here we go.
What's up?
This 2L, this coming Saturday, the 2 Ls will be
Oh,
writing
yeah.
essays in the morning.
In the morning.
If you have any suggestions, okay. What we should probably do is give them the sample question
Yeah.
for our review next week and have them all write on it
Yes.
Saturday.
I think
No
that's
excuses.
excellent
Great
idea.
idea.
No
Yeah,
excuses.
excellent
Great
idea.
idea.
I think we should give them Field of Dreams.
Okay.
We should give them Field of Dreams.
If you build it, they will come.
And see how they do with it.
Oh, God. Rake and soda. So, Moonlight Graham. Moonlight Graham. You know, the real Moonlight Graham did play in only one major league game. But after that one major league game, he played 3 more years in the minors. So it wasn't like the movie where he's like, oh, I'm going home to be a
Right.
doctor and, you know, marry Venetia or whatever her name was, Letitia, something like that. Always come home with a blue hat. Oh, that was such a great movie.
That really was.
There were some really good actors in that.
We, when we went to Vegas this last trip, we went to the Mob Museum.
Oh, wow, that was good.
And, fascinating.
Couple shot up cars.
Oh, man, it was really, really a neat experience.
Yeah.
And they had this one area
Let's go.
that had to
Straighten
do
out
with
what cases are.
the mob and sports.
Yeah.
And fixing sports.
Yeah.
And there was a whole section on the White Sox and
The Black Sox.
Black. Yeah, it was just a neat.
That is why I always thought Pete Rose was such a fucking idiot. It's like, if you know anything about baseball history, you know the sport was almost destroyed by the Black Sox scandal, which is why they have a rule about gambling, right? You don't do it, right? You don't, and it's posted in every clubhouse. And Pete Rose knew that. He walked by that sign every goddamn day as a player and as a manager. And well, people are like, well, but he was betting on his teams. That misses the point. He was betting on baseball.
Right.
And somebody knew that he was betting on baseball. And don't you think that that might give them some leverage over him? And then when that whole thing with the NBA with that corrupt ref that was like, gambling on basketball games and, whatever. It's amazing how quickly that turned into he was fixing games, and he clearly was, even though he denied it.
Right.
And like tons of money's involved because these guys know that guy knows that something else, and so when they bet this way, when these guys bet this way, and the line moves, and
But like there was plenty of examples, and some. I mean, a lot of them I had heard of, but some I hadn't even heard of.
Yeah.
Big deal in college ball. Apparently, it was very common.
Yeah.
That was
back in the
that
50s.
was where you could get in. You could get to them all in the pro. And just
As long as they're sports, they score together.
oh yeah.
Because I'm like, I don't understand.
And we had
I
a
never understand.
really good time.
Yeah.
That place was
It's like,
Where's it at?
downtown area, just off of Fremont Street. It's a block or two away. It's not on Fremont Street.
Yeah.
And it's an old post office building. It's a basement and it's got like 4 stories and each floor was a little bit different. And they had this whole, and you know what, not just was it a post office, it also was a courthouse. Because the second floor was a courtroom and it actually was the courtroom that what's this guy's name? Senator Kefauver's hearings
Right.
were held in
Yeah,
that courtroom.
from Tennessee.
And it was really neat. They had up where the judges that they had a big screen come down, and then there was a screen over in the witness box and a screen over here, and it was asking questions and the witness would talk, and then it was really well done.
Yeah.
And it was the actual
That
audio.
sounds pretty cool.
Oh, it was. We really enjoyed it. I didn't. It was crowded,
Yeah, I had one.
and so a lot of stuff were on the walls, and if you're watching and you want to actually take it in and read and whatnot, then people are getting it.
Yeah.
It was a mess. And if you try to get out and go somewhere else, and good luck getting up to where you. It was crowded.
Yeah.
Really enjoyed it.
Yeah.
I would recommend it. And it's they had this one section. What's this guy's name?
Alright. Did you take a look at that?
Nola or something. He was like
Oh, it's like.
the Vegas gangster. He was, I don't know if he was part of the Gambino family or something, but he was the Vegas guy. And he had the same lawyer who represented him for years. And they had this section about all the awards this guy from the state bar, from the local bar associations, and he was attorney of, in all these magazines, and he was just, and ultimately I think he did time in prison.
Of course he did, because you know what, do you know what the prosecutors do?
So.
If you're a real good criminal defense lawyer, the prosecutors say, you must be a criminal too. And so we're gonna take you down so you can't keep getting those guys off.
Exactly.
At least that's F.Lee Bailey's. F.Lee Bailey's version is if you are a really good criminal defense lawyer, the prosecution's gonna come after you because they don't want to lose it.
Right.
And of course, the prosecution version is, you're a criminal.
Right.
So.
And you're only saying that
These
to-
are things that someone.
But that happened with, what was that guy, that Bruce Cutler or whatever, that represented the Dapper Don, whatever he was.
Right.
John Gotti,
Yes.
right?
And you made.
And eventually,
Yeah.
get him.
Yeah. Yeah.
Oh, yeah, when I was in college, my mom bought me a book by Calendar. And I was just about stuff by that.
Right.
And of course, I'm thinking I'm gonna be a criminal defense lawyer. Yeah, I know.
He's taken a lot of flack of late.
Yeah, and he says because he's being consistent and saying it doesn't matter what party the president's from, he's got rights like everybody else.
I think that.
Of course, all his Democratic friends are like, you're an idiot. How can you be like talking good about Trump?
It's
Things are under the wrong title.
I don't know. I've got a number of his books. He's a decent writer. He's not a great writer. He's a decent writer. And the other, I think my mom might have gotten me one of those too. F.Lee Bailey that he wrote about the Patty Hearst trial and some stuff like that. And man, when I was I don't know, 18, 19, somewhere, I devoured that stuff. This is like the most interesting stuff ever.
right.
And man, I want to be one of those lawyers, fighting the man thing or whatever. And somewhere along the way, I decided, I want to be a lawyer at a big firm. Do what those guys do. But if I had to do it over again, I would have gone to work for, like you did, go work for the DA's office, at least for a few years. I might go back and do civil after that, but at least for a few years so I'd feel comfortable in a courtroom and,
Yeah.
feel comfortable comfortable asking questions. And would have helped out a hell of a lot when I became a judge.
I really, like I said, I enjoyed my time there, but I'm enjoying my time now too.
Well, you know, it's really refreshing to have like a do-over or a reboot or whatever you want to call it with your
Yes.
career after you've been doing it for a while.
Right.
I was a lawyer for 19 years, and then I get to re-rack and be a judge. And it was very refreshing, and I learned a whole bunch of new stuff, and it was just really cool.
Right.
And apart from the fact that I like the job, you know, whatever, that was just really good. It was a real refreshing new start to or continuation of my career, and I never regretted it for an instant because it was intellectually stimulating, and you know, just that was great.
That's kind of where I'm at. I mean, it's everything, not everything. I mean, I'm getting the hang of this now.
Yeah.
So it's, but it's new, and I'm looking into stuff, and just, you know, it's not the same old thing.
Yeah.
It's definitely a very different area.
Yeah, Tom, remember Tom Kerriman, you know, who does probate murders right now? And I remember Tom talking about, you know, if you're practicing law, especially civil, what you end up doing is a particular type of case. And because you get really good at that particular type of case, what Joe Jamil used to call sore back cases, you know, and you're doing 100 sore back cases because you're really good at that.
Right.
But it gets a little old and boring, and it's not very intellectually stimulating, kind of like doing what I'm doing right now. You have to write to a preliminary hearing in 10 court days and 60 calendar days, you figure what, you know. Anyway, but when you're a judge, you get to do all sorts of different things, right? You get a civil assignment. One day it's a sore back case, then it's a, you know, an injunction, then it's a this, and you know, a business dispute, you know, and all that. Oh, and then you go to probate, and it's a completely different thing.
Exactly. Yeah, it's
But, yeah, one thing that was fun about civil, the substantive law is a lot more complex than
Oh, absolutely.
criminal.
Absolutely. And well, you don't have one code, right? You don't have the one code. You go criminal, you go to the penal
Penal
code.
code.
Oh, wait, maybe a welfare and institution.
Yeah,
or health and
that's
safety,
it.
you know.
Unless you're doing a jury selection, in which case you're gonna go to civil procedure.
Right.
Why? I don't know, because that's where they put it.
But it was, there's a lot of different codes out there.
Yeah.
It's like, what do you practice? Yeah. Oh, I gotta go to government code. Oh, I gotta go to
No, or the water
Water.
code. Oh. Or the civil code.
I know, cool. There was a civil code, go figure.
And then, where did they hide the parole evidence rule? In the Code of Civil Procedure. Isn't that an evidence rule? Well, it sort of is, but not really.
Not really,
Oh, man. Oh, my head's starting to hurt.
How about a contracts rule?
Yeah, well, there's that too. And then my favorite, the equal dignity rule.
No. Tender years doctrine.
Tender years, That sounds interesting.
Hmm?
That sounds interesting.
Well, for the young, under 12 victims of, Child abuse?
Oh, is that what that is? Does this save automatically?
Yeah, sure. Hey, Isabel, you know, you posted on your birthday evening
Yeah.
what you were doing. I want to do the same thing.
You're doing the same thing?
I want to do the same thing.
Oh, you're doing the same
like,
thing. Oh, it's
yeah.
tomorrow, huh?
Your birthday's tomorrow?
Mhm.
Well,
That's
the
so
three of
weird.
the three of us are 3 days apart.
I know, everyone's,
Well,
that is so
I
weird.
just put one of my high school friends a wrong person today because I switched them around. So it's her the 5th and me the 6th and the 7th. I switched them around. So they're like, hey, happy birthday. He's like, oh, thanks, but it's on Thursday. I'm like, oops. Yeah.
You're like, I wanted to be the first one.
Ta-da. Too late.
So cool.
Yeah.
Yeah, I'll figure out how to open the door eventually. I've only been coming in and out of this classroom for how many years?
All right, just a quick announcement before we knock out these last few questions. Apparently you guys are going to be writing on Saturday. We are going to send Veronica a review essay that we're reviewing next week. No reason why you guys can't write it, and then we will go over it on Wednesday.
In preparation for the midterm.
So, I was looking around the room here and I'm trying to figure out who is it that hasn't gone yet? He's gone. Trisha's gone. I know.
That's not me.
So, are you volunteering?
I have not gone.
I know,
But no, I'm not volunteering.
We only got a few left. Who wants to jump in there? Who hasn't volunteered? 10:51.
All right.
Yeah, right.
All right, I like it.
I guess.
All right, so Hope is charged with selling illegal drugs. Hope's partner in the illegal business was Benny, and the prosecution seeks to offer into evidence against Hope a conversation that Benny had with Diller. In the conversation, Benny described how he and Hope did business because he believed that Diller planned to join the partnership. In fact, Diller was an undercover police officer who recorded the conversation. When Benny refused to testify against Hope, the prosecution offers into evidence the recording of Benny's conversation with Diller. Assume that Benny's statements would be admissible in evidence against Hope under the co-conspirator exception to the hearsay rule. Are Benny's statements to Diller testimonial for purposes of the Confrontation Clause?
Okay, so the question has nothing to do with hearsay, right?
Right. Has everything to do with testimonial?
So we've narrowed it down to, is it testimony?
Well, if you look to the intent of Diller, who was the undercover police officer, his intent in recording the conversation was to use it at a later trial. But the conversation, from Benny's point of view, as he's the declarant, he thought he was his business partner and didn't know that he was an undercover officer. So it would not be testimonial in that regard. But under the Davis analysis, and looking at the primary purpose test, the primary purpose is recorded to use it at a later trial.
Have the police got any other purpose?
No.
No. They've already identified defendants. They're like gathering information, but it's not a formal interview, right?
Okay.
Certainly the dude that's making the statements doesn't intend to help the police. Right?
Right.
So what do we think?
I would lean more toward that is testimonial.
Anybody want to take the non-testimonial side and pick a fight?
No future prosecutors in the room.
You're just gonna give this evidence up?
These cops worked hard to get this evidence, man.
Well,
Well, he's an undercover police. So he was unaware that he was talking to police.
Right.
Therefore unaware that it would be used.
He didn't intend this to be, help the police.
I never thought this was gonna be used in a later trial. You know?
Yeah.
And as in anything else, you take your position and you support it. Is there a right or a wrong? Not really.
I feel like especially in this question, because I feel like the arguments are pretty weighted on both sides. I don't know, I guess I would lean more towards testimonial, but very slightly, because he had no idea that he's being recorded and thought it was his business partner.
Yeah.
How is that different than little Claire talking to her babysitter?
Because it wasn't recorded.
Yeah, the babysitter's not trying to put together a criminal case.
Yeah.
Right? Babysitter's just a
But Claire
babysitter.
doesn't know that. Right? If you want it in, just keep this in mind. Undercover cop. If you want it in, you focus on the intent of the declarant
Yeah.
and the fact that he clearly never thought this was going to be used against him because he didn't know he was talking to a police. Right? If you want to keep it out, it's a cop.
It's a
He's
cop
talking to a cop,
putting
and it
together a
doesn't
case.
matter if he knows it or not. The cop knows he's a cop.
And the cop knows what he's doing.
So, those are your two basic arguments. And which one wins?
We decide.
And in court, you probably would get different rulings as well. Right? There's not a rule, at least in California, that's come down that said if you're talking to an undercover cop, it's testimonial because he's a cop. There's not that case. And there's not a case either that says, because he's an undercover cop, it's non-testimonial every time.
And honestly, there are some judges that just don't like Crawford very much because they like the way the law used to be. And so if you can get it in under the hearsay law, they're looking for a way to find that it's not testimonial. And other folks like Justice Scalia, that are more, hey, this is a goddamn constitutional right. Maybe the most important right we've got, the ability to confront and cross-examine witnesses. So.
But you know who would get to confront and cross-examine the witness? Benny. That's what this is. This is leverage against Benny.
Yeah.
Benny, you gonna testify?
Nope.
Okay. You're going down.
Yeah.
Right? This will be used against you.
Oh, yes.
We might not use it against Hope, but we're gonna use it against you.
Oh, and by the way, we're making a deal with Hope to testify. Anyway.
So how long you want to spend in jail? Scratch my back and scratch yours.
Assume responsibility early in the criminal process.
Usually the one that doesn't have any hope is the one that wants to talk.
In this case, that would be Benny. Because Benny's on tape.
Right? Does Hope want to talk? No, because her lawyer's telling him, they don't have anything against you. All they got is Benny.
And by the way, Benny's a lying sap.
Yeah.
He's the drug dealer just trying to lay it off on you. So what happens after Benny pleads guilty? Benny gets on the witness stand and says, it was all me. All that stuff I told the cops, that was all lies. Now that I've taken responsibility, it was all me. Hope didn't do anything.
And the juries believe him.
No.
But they think they do.
I so had that case, right? I won't tell you who the prosecutor was. You may know. You may be able to guess. Anyway, prosecutor has statement from defendant one, right? And after I rule in some pretrial motions, defendant one says, okay, I'm screwed, and pleads guilty. So now prosecutor says, make defendant one testify. And defendant one's lawyer like, well, he might appeal. I'm like, he's not going to appeal. He just pled guilty and waived his right to appeal. So he's got to testify. So of course, he gets on the witness stand, and what does he do? All that stuff I told the police when I was denying that I was involved, that was all a lie. Because now I've taken responsibility. And I pled guilty, and I've taken responsibility, and it was all me, it wasn't the other guy. Which, of course, in the statement to the police, he was like, it was the other guy, it was the other guy, it was the other guy. And of course, part of the dynamic is defendant number one who pled guilty, he's going to state prison. And does anyone want to go to state prison with a reputation of being a rat? No. They're not real popular in state prison. So he had like every reason to lie after he pled guilty because he's already getting sentenced, whatever. So now the prosecutor's like, well, shit, I have to use the statement, prior inconsistent statement, to try to convince the jury that he was telling the truth then and lying from the witness stand. You know, the part where he was under oath after he pled guilty and had nothing to gain. Anyway, it was an entertaining trial. So what did the jury do? They believed his original statement to the police. But it was an interesting trial.
But if you had used the original statement against him, standing alone, probably don't believe it. But you're lying to the cops.
Anyway,
We digress.
So if you are a prosecutor, here's what you don't do. Don't plead with it. Don't make a deal with defendant one that you have the statement from and expect him to say the same thing when he gets on the witness stand after he pleads guilty. Because he's not going to do that. No matter how great this statement is. Anyway, moving on.
Alright, change the foregoing problem as follows. Benny is on trial for selling illegal drugs, and Benny's statements to Diller that the prosecution seeks to offer into evidence were made after Diller arrested and interrogated Benny. Assume that as a matter of hearsay law, Benny's statements are admissible as parties' admissions. How should the judge rule on the following argument of Benny's attorney? Your Honor, I object to the admission of Benny's statements to Officer Diller. Those statements are clearly testimonial. Moreover, my client intends to exercise the constitutional right to remain silent by not testifying at trial. The statements are thus inadmissible under Crawford because Benny's exercise of the right to remain silent means that the defense has no opportunity to question or cross-examine Benny. To admit Benny's statements into evidence would improperly punish Benny for exercising a constitutional privilege.
Anybody think that's a persuasive argument? It sounds like a really good argument,
Yeah.
right? Hey, I've got the right not to testify, and you're denying me that right by introducing this statement that I made to the police. Because the only way I can refute it is to have to get on the witness stand, and then, Anybody think that this is excluded? Do you have the right to confront and cross-examine yourself? Yeah. No. You don't have the right to confront and cross-examine yourself.
If this were a winning argument, then every statement they make to the police would
Never
never
come
be
back.
used against them.
That makes
Right?
There's one witness you don't have the right to confront and cross-examine. You.
All right. Stand for due.
Now, notice that if it was somebody else that was exercising their Fifth Amendment right, that would make them unavailable, okay? And you wouldn't be able to confront and cross-examine. So that's a great argument for some other witness, but not you.
About 10:52.
Okay, brothers in lawlessness. Can you hear me?
Yes.
Yes.
Okay. So the Urban Police Department has created a special task force in an effort to cripple a violent street gang. The 17th Street Crisps?
Yes.
Okay, Crisps. Headed by the Sam brothers, Flott and Jet.
Oh, yes. Lots of them and Jetson.
The UPD has distributed fill-in-the-blank witness sheets to residents and merchants in the gang's area. The witness sheets ask people to join in the crisp crackdown. By filling out a sheet as soon as they become become aware that a crime is in progress. They are to fax the sheets to a special phone number. When a police dispatcher receives a fax, the dispatcher immediately notifies gang unit officers who are generally on patrol in the area. In this case, Flott and Jet are charged with murder. The prosecutor seeks to offer into evidence a witness sheet prepared by Molly McGovern. McGovern wrote, Flott and Jet hiding in the neighbor's bushes, loading handguns, wearing dark clothes, pointing guns at dark sedan, shots fired, F and J jump into blue sedan, driving away south on 17th. The police dispatcher received the fax at 10:02 a.m., a few moments after the time other witnesses reported hearing shots fired. With McGovern unavailable as a witness, the prosecutor offers her witness sheet into evidence. Are the statements on the witness sheet testimonial? And, okay, so it would be testimonial because it's believed to be used against them. So it used at a later date.
What about the fact that the crime is kind of like ongoing and they're fleeing from the murder scene at the very time that the statement was made to the police?
Well, I saw that too because that's the next question. Was it prepared in the course of an ongoing emergency? And yes, it was, because it was ongoing. It was happening at that time.
Literally like a call to 911, right?
Yeah, I think that threw me was a fax. Because
Yeah,
that's kind of later.
that's like a little different than calling 911 and giving the exact same information, right?
Right.
Except is it really?
Okay, then I would see it, okay, then it would be I'm just thinking of fax, it just takes forever, so it's after the fact. So
Yeah, but it's really soon after the fact.
It says minutes, a few
These
moments.
guys-
minutes, okay,
These guys are armed. They just shot somebody and they're fleeing. And a witness calls the police and says, hey, I saw these guys, they're armed and they're fleeing. Now, if that's what it was, you probably would say the predominant purpose is to help the cops deal with an emergency and catch these armed, dangerous bad guys, right?
right, okay.
Does it really make a difference that the police have anticipated that this gang is going to commit some crimes and made it and facilitated witnesses communicating with them almost contemporaneously with the commission of the crime? Does that make such a difference that we're going to call it testimonial?
Well, I think I'm confused because isn't under Bryant an ongoing emergency?
Yes.
Yeah.
So wouldn't that make it in the intent under Davis, because there is an intent, so wouldn't that make it testimonial?
Well,
What's their intent? Is their intent to provide information of a crime that's already committed? Or is it their intent to provide information of something that is ongoing?
Oh, okay. So it would be, okay, so it's to make it ongoing.
but if you wanted to say it's testimonial, couldn't you say, look, the cops are trying to do their best to gather information about crimes that are going to be committed. And that's why they've talked to the neighborhood and said, here's how you document what happened. And we want you to help us put together cases of when crimes are committed. But what makes this probably not testimonial is this whole thing isn't over yet. This isn't like a witness says, hey, I saw something last Thursday, I'm going to fill it out and fax it in. It's like the shots were literally just fired. The smoke's still in the air. Witnesses are calling and saying, hey, we heard shots fired. And this witness says, hey, I got this form from the police. I saw these dudes. They're in this car. They're armed, and they headed this direction, and faxes it in. So it sounds an awful lot more like that 911 call than the, hey, the police are canvassing to try to get information about this crime after it's been committed.
Okay,
So with
okay.
all of that, what do you think?
Then all of that, I'm thinking it's non-testimonial because it's still ongoing. It's happening right now.
Yeah, this emergency is, the police are hopefully in hot pursuit. And they just found out who to pursue and where they're going. But if it's tomorrow, right? If it's 3 days from now, if it's next week, maybe a different result, right?
Or if it already happened, would that?
Yeah, right. So
Okay.
if it's like a week later and you fill it out, now maybe you still haven't caught those guys, right? Maybe you still haven't caught the guys. They're still out there. They're still armed. We know they're really bad because they're gang members with weapons who murdered somebody. So maybe you still got an argument that a week later, you know, if you're trying to track down murderers who are armed and dangerous and hiding out somewhere in the community, maybe you're still trying to solve that emergency. And maybe you still could get him.
Okay.
But minutes afterwards, yeah, you're probably dealing with an ongoing emergency. And it's like that 911 call. But yeah, what kind of throws you is it's in writing and the police clearly anticipated trying to gather evidence, right?
Yeah, that's what
Yeah. So everybody see how it's like really fact specific? Probably the intent here is to help the police like catch the bad guys right after they committed the bad guy stuff.
And counter that with, I saw this occur 2 weeks ago. Here you go. I'm faxing this into you. Exact same facts. I saw them. They were in bushes. They had guns. They shot a car. They jumped into this other car and fled. But it happened 2 weeks ago. And here's the information for you. You see the difference?
Clearly the witness knows she's talking to the police because she filled out a police form and sent it to the police. Clearly the police are trying to gather evidence to help prosecute somebody, catch somebody and prosecute them. So without that ongoing emergency, it's got to be testimony.
Does it matter, right? We focus on the intent of the form filler outer person, right?
Here and after, the witness.
The witness.
Or
right?
declarant.
They filled it out. Does it matter that the police will say our primary purpose was not to investigate past crimes, but to only investigate crimes in progress, ongoing emergencies?
And they will say that with a straight face.
Well, that's what your facts tell you, right?
Yeah.
That's what your facts say. They want you to fill out the sheet as soon as you become aware that a crime is in progress. So I know defense counsel saying, well, you sent this out because you want information about crimes that already occurred. No, we specifically told them we want information about crimes that are in progress. Does that matter?
It's the intent. So takes away from primary purpose.
So it would be, I mean, I guess you would argue it both ways, but I think the court would say that it's the intent of the person sending it that has a heavier weight,
Why does that matter more than what the police want?
because it's the intent of the person that's.
Doesn't the intent of the cops matter?
He thinks it does.
I think it does, but I don't think it matters more than the person's making the statements.
Why me? I mean, I do think it does, but
Well, you did in your question.
yeah,
Right, that was
because apparently that's what has to be done. I don't agree with it.
Yeah.
I think whoever the declarant making the statement, I think their intent should have greater weight. But
Well, let's just say something happened, you're a witness, you saw this shooting go down, you don't want to get involved, you don't want to get anybody in trouble, you don't want to say anything. And the cops come up and say, hey, get in my car, let's go. They drive you down to the station, they put you in the interim, they put the bright light on you, make you start sweating, they turn the recorder on, right? And then they come in, they start banging on the table, tell us what happened.
We know you know something.
Clearly, the police are trying to get information. The declarant may be saying, I got nothing to say, I don't want to say anything, but ultimately says, well, here's what I saw Flott and Jet do.
Just leave me alone.
Right? Police have an intent, and it's not to deal with an ongoing emergency. It's to solve past crime and prosecute the offenders, and the declarant doesn't want to be a part of that. So that's why you've got to look at what are the police questioning, right? Are they questioning to elicit facts to allow them to deal with a situation that's ongoing? Or are they trying to elicit facts from something from the past to develop a case for prosecution, right? And one of the factors you look at is the level of formality of the interview. Who are you talking to? Where are you talking to them? Are you on your front porch? Are you out the street beside their police car?
In their police car, in the squadron, or in an interview room that's being recorded after, some sort of like formal admonishment about identifying the lineup and how it's important to clear innocent people just like it is to catch guilty people and stuff like that.
Right? It's one of those situations. You've got to consider both. Okay. And your analysis really is going to break down to which one is most important, which one is most believable, right? Just the fact that they say something, either side. If the declarant comes in and says, oh, I was just scared, I wanted the police to come and help me. But in reality, they knew exactly what had happened. They're trying to get somebody in trouble.
Well, and
Which
similarly,
people do.
And similarly, the police are like, hey, we were just asking for information about ongoing crimes with that form. We didn't expect people to fill it out 2 weeks later. Yeah, right, sure.
So, right, these are things that you have to take into consideration. Does it matter? Of course it does. Is there a reason why those facts are put in this question?
Of course they are.
Of course they are. And what do you think that means? Right? The witness sheets ask people to join in the crisp crackdown by filling out a sheet as soon as they become aware that a crime is in progress. Hint, hint, talk about what the police intent is. Now, of course, if this came in and it talks about something that happened 2 weeks ago, are the police going to say, well, this was 2 weeks ago, we're going to throw this away. We don't care about this one. Of course not. Right? So, but those facts were given to you for a reason.
So there's some like the basic reasoning here, I think, is to say, you know what, this sounds an awful lot like where the crime has just happened. It sounds an awful lot like a 911 call, right? You're giving pretty contemporaneous information to the police. And the fact that you wrote it down and faxed it, although it sounds like, hey, that takes a long time, it gets to the police pretty soon after the crime's been committed. And we know that somebody in the police station is, pulling these things off the fax machine like right away, right? Because we haven't heard, hey, and the police didn't look at the statement for 3 days. Okay, so I think given the facts that we were given, it's probably a lot like a 911 call.
Okay. They even told you. Well, who does the fax go to? The dispatcher. Right?
Dispatchers, the answer 911 calls.
Right? answers 911 calls, right? So they want you to
And
consider that.
just intuitively, if it was, hey, public, email us at, Indio Police IPD emergency at ipd.gov, right? That sounds a little bit more like we want to know about emergencies right now, right? And that would seem more like you're trying to get a contemporaneous report, right? So, but yeah, that whole fax machine makes it sound like it's antiquated and going to take a week and a half before anybody looks at it. Because nobody faxes anything anymore.
So what about, with social media, what about tweets? People are tweeting at the scene of a crime, I saw this, what they saw.
And who are they communicating that with? The world,
The
right?
world.
Yeah. So it's probably not just intended to go to the police. I mean, it's probably intended to let everybody know, hey, I'm an important person. I just saw something. Sounds less like it's intended to provide information to the police about something that's already happened. More like that statement to the babysitter, or all your Facebook friends, or your Twitter followers, or whatever.
If it's not sent to somebody with authority, right, to investigate things like that, right?
Now, suppose you put at IPD. Jet and Flock just
Okay,
shot
yeah.
at dude at Miles and Monroe and fled in a blue Honda eastbound on Monroe or southbound on whatever the hell direction Monroe goes, right? That sounds like a little bit more like you were trying to tell the police, right?
Yeah.
But it's also more like you were trying to tell them about something that's going on right now. I hate social media. It creates all sorts of problems.
Okay, let's hit a couple more.
Ooh, what if you did an Instagram photograph, right? Put it up on Instagram with some reference to IPD in the picture.
Yeah, part of that's probably it's gonna matter. Is somebody monitoring that? Are they getting it soon, or are they just seeing it the next day, or what have you? If they have, saying, I have somebody that monitors our Instagram account 24 hours a day. And when we see something like that, we dispatch somebody out immediately. Well, maybe it's different. Let's consider the admissibility of hearsay evidence under the Confrontation Clause in the following circumstances. Joe was charged with a DUI. Under the DUI statute, that makes it a felony for a minor previously convicted of drunk driving to drive while under the influence of alcohol or other drugs. To prove that Joe drove with a blood alcohol level above 0.08 and thus was intoxicated, that Joe was a minor at the time of the offense, and that Joe had previously been convicted of drunk driving. At trial, the prosecution offers the following into evidence: a court clerk certificate stating that an attached document titled Abstract of Conviction is a genuine and accurate copy of a court record indicating Joe was convicted of drunk driving 6 months prior to the date he was arrested on the current charge. Can you get a prior conviction under Crawford?
Silence is deafening here.
Yes. The stamp by the clerk that certifies it is not deemed testimonial, right? It's an official record.
And why is that? Because it's a prior conviction.
So a county clerk certificate saying that the attached certificate of birth is a genuine and accurate copy of a county record, indicating that he was 17 years old at the time of his arrest. That is the basis of the current charge. Certified birth certificate.
Not testimonial.
non-testimonial. Right.
Yes,
And
because we don't maintain birth certificates to prove that dudes were like guilty 17 years later. Right,
Right.
seriously. I
Yeah.
mean, isn't that sort of the analysis,
Yeah.
right? Was the statement of the registrar or whatever when they issued the birth certificate intended to prosecute a criminal case against the poor baby nearly 20 years later? No. Okay.
an analysis report prepared and sworn by Ronald Houston indicating that Houston is a licensed lab analyst. He administered a breathalyzer test to Joe in accordance with the standard lab procedures following Joe's arrest on the current charge and obtained a readout on the machine indicating that Joe's blood alcohol was 0.12.
Oh man, this sounds an awful lot like a real case.
Testimonial.
Agreed.
Yeah, because what's the point of doing the breath? Yeah, of course.
A breathalyzer test record prepared and sworn to by Judy Shackelford indicating that as an employee of a breathalyzer testing company, she conducted a routine test of the breathalyzer machine used to determine Joe's blood alcohol level 2 days before he was arrested and determined that the machine was in proper working order. You see the difference? The first one is the report of the analysis of his breath. The second one is a report saying I tested this machine and it was in proper working order. Testimonial?
No.
More towards no, but
Yes.
I think you could make the argument that the reason she's conducting that test in the first place is to see that the machine is fit to administer the test, which determines whether or not they were drunk to use that in prosecution later.
Make that.
But then the other side would say, well, it's just a routine test, you know, that she conducts.
And it's just as important to make sure that people don't have a blood alcohol of 0.08 than they do. The machine's got to work right either way, right? To present evidence that the defense would like to use and say, hey, they tested it, man, it was like 0.04.
Okay. Prior to trial,
Oh, man.
Joe's lawyer tells Joe that even though we don't contest your age or your prior drunk driving conviction, I'm going to make Melendez-Diaz bull-cumming objections anyway to all the documents above when the DA offers them into evidence. The lawyer further advises Joe that when DAs rely on documents rather than live witnesses, the confrontation clause can be the defendant's best friend, right? Melendez-Diaz and Bull Cummings said what?
That you can't use a lab report unless the lab technician or something is unavailable.
Right. Both of them had to do with forensic lab reports, and both of them said that you needed live testimony, not just the results itself. Okay, so is the attorney's position ethically responsible? Is it ethical to make a Melendez-Diaz bull-cumming objection to all four of those documents? I got a yes. Anybody say no?
I think yes.
Is it ethically required?
He needs to raise that argument.
Okay. Well, you got a court certificate for his birth, and I'm sorry, for his prior conviction, and a clerk certificate for his birth. Do Melendez-Diaz and Bull Cummings say anything about those two documents?
No.
Does that change your analysis whether making a Melendez-Diaz Bull Cummings objection to those two documents is ethically responsible?
Those. I don't think those he has an ethic responsibility to raise it against those two.
Okay, but if you know that the objection isn't valid, I mean, assuming you know
Yeah.
that it's not a valid objection,
Mhm.
you're gonna make it anyway? On the hopes that the judge won't know it's not a valid objection?
That's unethical if you know.
Because you don't have a good faith argument for the extension modification or, what was it? Reversal of existing law, right? I don't think you got a good faith argument on that. At least as to those two documents.
And assuming that the DA offers the documents above into evidence in lieu of live witnesses, and that Joe has not previously had a chance to cross-examine any of them, how should the judge rule on the defense attorney's confrontation clause objection? We kind of went through that already. The first two are probably coming in. Third one for sure isn't. Did we come up with a conclusion on the machine working properly and calibration? Do you think you get to, you have to bring that person in? You want everybody to come in.
Doesn't it say that?
You typically don't, right? If you have a witness whose only role is to make sure that the machines are working properly and doesn't have any specific information as to the results, you typically don't have to bring them in. Because you got to bring the other guy in, right? So when Ronald Houston comes in, was this machine working properly? Yes, it was. How do you know? Well, I reviewed the records and there was no problems indicated.
Objection, hearsay. Anyway.
And why isn't it hearsay?
Because the machine is declaring.
It's a machine, and it's also, they typically are qualified as experts when they come in, and they're allowed to rely on other information to testify about what they did and the opinions that they formed. Okay, and just so you know, that's not the law in California anymore, right? Volcoming and Melendez-Diaz have been overruled in California. I mean, you can't just bring the certificate in, but you don't have to bring the person in that took the test. I remember we went through some of those where you can bring, the supervisor can come in, and if you've got an expert who formed their own opinion and whatnot, they can testify to their review of another person's work.
But you may have to bring in some proper evidence of the chain of custody to make sure that those drugs that were tested by the lab were the ones that were taken from the defendant when he was arrested.
Okay. Questions on Melendez-Diaz? Milt is charged with assaulting Nguyen with a deadly weapon. Officer Amati finds Nguyen lying dazed and bleeding in the alley. The officer asks Nguyen, "What happened? Are you okay? Should I call an ambulance?" We don't know what the question is, but what type of questions are those? Those are not investigatory type questions. Those are emergency situation type questions. What happened? Are you okay? Should I call an ambulance? And when then says to the officer, "Thank God. Don't know why somebody wearing a Star Wars mask ran out the back door of a store, slugged me with a metal pipe. My head hurt so bad." Assume that Nguyen's statement would be admissible in evidence as a matter of hearsay. Is the statement testimonial?
This is in response to the "Are you okay? Should I call an ambulance?" kind of question.
Right? He's dazed, he's bleeding in the alley. And this is what he says. He's not really accusing anybody at this point. He's just articulating what happened.
So
Anybody
then
think,
10 minutes later, the cops arrest a guy in a Star Wars costume with a gun.
anybody think this is testimonial?
Well, the crime
Maybe.
Yeah.
already occurred, so the interviewing officer gonna use that.
Gonna use it for what?
To identify the assailant.
Maybe at some point.
But
But right now, he's using it to say, do I need to call an ambulance? Right, do you need some help? Do I need to call on dispatch? Hey, be on the lookout for a guy in a Star Wars mask and with a metal pipe. He's not asking those questions to prove up a case, right? He's asking them to deal with the situation of a man laying dazed and bleeding in an alley that's presented itself in front of him, right? If you take the conclusion, the position that this is testimonial, you are probably going to find every statement testimonial. Okay, this is about as emergency as you get. Aside from somebody calling 911, a cop coming up to somebody who's obviously injured and saying, are you okay, what happened? Those are not investigative type questions.
And we don't parse, well, the answer, my head hurts, is non-testimonial, but the description of the guy's outfit is testimonial. We generally don't parse that conversation quite that closely.
But you look at the statement as a whole.
Yeah.
Right. So why would he identify them if it wasn't testimonial? Why would he, if it's really an emergency situation, right, and he's worried about, he's dazed and confused from getting hit in the head with a pipe, why would he identify the costume the guy was wearing if he wasn't trying to, perpetuate that this is gonna be used in a court case, later in his prosecution? I'm trying to recall
Okay.
what happened.
Let me play devil's advocate with you, right? Somebody runs in that door wearing a Star Wars mask and hits you over the head, and you're left dazed and bleeding. Pick somebody, it doesn't matter who, comes up to you and says, hey, what happened? And you say, oh, this guy came in wearing a Star Wars mask and hit me over the head with this metal pipe. Are you only saying that to further an investigation and for prosecution, or are you answering the question, what happened?
Well, I didn't think it was only, you had to make the statement only ensuing or trying to further your idea that this is a criminal investigation. It could be like a half and half, because if someone really came in here and hit me over the head with a pipe and I was really worried about an emergency situation, I wouldn't care who hit me. I would just be like, someone did, my head's bleeding though, it hurts. If it was really an emergency type situation.
I think it's a little bit much to say, well, the victim of the crime who's dazed and bleeding is forming the intent, I'm going to help the cops put together a criminal case when I say the description, but I just am looking for help when I say my head hurts a lot. I mean, maybe.
But it's interesting, talking about, what you're talking about, like, what if a car hits you, you're a pedestrian, you get hit by a car, and from past, watching every crime show.
Yeah.
Oh, I gotta get that license plate.
Yep.
Number. So in that respect, you are, doing that for the sake of, finding out who did it.
And before I forgot it. 'Cause
So that-
So then there is no.
Huh?
Then all there is testimonial statements, right?
Yeah.
If you're talking to a police, given what we all know, having watched TV our lives, right? That if you talk to a police, they could use that at a later time, right? No, and then the lawyers come in, and then you're gonna go to court, right? We've seen Law and Order our whole life. We know how this works. If you get that stringent in your analysis, you're gonna come up with the conclusion it's testimonial.
Mm.
Take a step back and ask, what has been the trajectory of the Crawford cases? Have they been to reaffirm?
Kind of
You
swing
talk to a
places.
police, it's testimonial, or have they been to say things aren't testimonial? The cases more and more are, they're not testimonial. Okay, it's a very specific type of statement that is deemed testimonial. Okay, and answering a question, you know, how are you doing? What happened? Do you need an ambulance? It's probably not going to be deemed testimonial. Okay.
Now, 3 weeks later, when you go down to the police station and the police say, I want to go over what you said. I want to see if you remember anything else. I want you to tell me about the medical treatment you got so I can try to figure out, or so that I can help the prosecutor figure out whether you suffered a great bodily injury. And you do that interview at the police station and they show you a lineup and they give you the admonition about the lineup and all that. That's testimony, right? Because why are we doing that? We're trying to put together the criminal case. The statement at the scene while you're still dazed and waiting for the ambulance, not testimony.
Everybody see that? Well, I don't want you guys to think this, if you're going to err, erring as non-testimonial is probably your better bet than erring that it is testimonial.
Especially unless it really does look like the police are putting together the case. They're doing a formal interview of you. They're getting a sworn statement. They ask you to like sign it, you know, all that.
Green, charged with the premeditated murder of Venuti, supporting Green's defense of insanity as Dr. Loeb, who testifies that Green suffers from schizophrenia, and that because Green had not been taking his prescribed antipsychotic medications, Green was incapable of planning or understanding that he could harm another human being. In rebuttal, the prosecutor calls Dr. Leopold. Dr. Leopold's opinion is that Green suffers only from a mild form of schizophrenia, and that Green committed the murder to prove that he is a superior human being who can get away with the crime. Dr. Leopold arrived at this opinion after extensively examining Green and interviewing Green's parents. If Green's parents are unavailable to testify, and Green has not previously had an opportunity to cross-examine them, would the confrontation clause prevent Dr. Leopold from testifying to their statements?
Anybody?
We don't know what the statements are, right? But we can do some analysis. Why is Dr. Leopold talking to them?
To see if he's competent to stand trial.
Maybe. Well, it doesn't say they're talking about competency. He's clearly talking to them to diagnose him mentally, right?
Who does Green work for?
The prosecution? Or no, I'm sorry. Who does Green work for?
Does it tell us?
Leopold works for the prosecution.
Yeah.
Dr. Leopold.
Oh, yeah, sorry. Yeah,
Right?
I mean, yeah, that's what I meant.
So
Who does Leopold
he's talking to them to evaluate his mental state, right? Whether that's competency or whether he's schizophrenic or whatnot, he's there to evaluate them. Are the parents talking to him to help facilitate a prosecution or a court case, or
No.
no? Is he talking to them to help the court case? Right, if you're the defense and he gives the opinion that you do have the ability to form the intent, then your position is, of course he does, right? But a good expert should be going in with an open mind saying, let me see what everybody has to say about this. And if Dr. Leopold came to the conclusion that he was not, that he was insane, that he does suffer from schizophrenia, the prosecution probably doesn't call him, right? Because it doesn't move their case forward. But and just a simple Crawford analysis, right? The statements aren't being used, given, or taken to help prove a case, right? Yes.
But now imagine that he's pled not guilty by reason of insanity, and the prosecution says, we want our psychiatrist to examine him. And Leopold's that psychiatrist. And Leopold interviews the family as part of the examination. That's gotta be testimonial, right?
Is it? He's an expert.
Well, doesn't he disclose what the purpose of the examination is?
Sure it is.
Sure. I've been hired by the prosecution to examine your son.
And so they know that he's doing that for, and then he's made the disclosure in his testimony.
Is
And
it?
other statements, whatever statements they provided.
Oh, no, I'm just here to help examine your son. And, if it turns out that I conclude that he's insane, I'm going to tell the prosecution, you should, he's insane.
Yeah, it's for future criminal trial.
Is a psychiatrist of person of authority.
So, I think is this the distinction that even though it can be used at trial, it's not gonna be used to prosecute him? Like if that's not the intention going in, that's what makes it testimonial or not?
Well, that's what you have to analyze.
Okay, that's the analysis.
Okay, that's what you have to analyze, and kind of like His Honor was suggesting,
Mhm.
right? Who hired you?
Mhm.
The prosecution. Of course, you're going to find that he's not insane. Well, you know what? Guess what Dr. Loeb's going to say? Who hired you? The defendant. Of course, he's going to say you're insane, right? We know how this works, but it doesn't work that way, right? I've seen plenty of exams where they don't tell you what you want to hear, and it's like, okay, and you don't use them. There absolutely are doctors out there that give you the opinion you pay for, and there are.
And the more silly you do, the more you'll run into those folks.
Yeah, and there are doctors who will give you their opinion. So
There's in a slightly different context, the abbreviation for certified appraisers is MAI, and the joke is, what does MAI stand for? Made as instructed. That they know what they're getting hired to come out with a value, and they do. One would hope that psychiatrists aren't quite like that, and that appraisers are more ethical. But a lot of times, if you're hired by the government to help the prosecution evaluate its case, statements made to you may very well be testimonial, just because of who hired you and asked you to do whatever work you're doing. But it's not a slam dunk.
yeah, so this kind of blurs with the laws around experts. Right? Can an expert testify as to the basis of his opinion? Of course, otherwise their opinion's worthless.
Yeah.
Right? Your opinion's only as good as what you base it on. Right? You got garbage in, you got garbage out. Here, what did you do? Well, I interviewed Mr. Green. I interviewed his family, and I interviewed his records.
And I reviewed the police report about the incident.
I did all of these things, and here's my conclusion, right? The difference there is you're saying you interview these people. You're not saying here's what these people said. You see that? As soon as you start getting into, well, what did they say? Then you're going to have an issue.
Can you repeat that one more time?
Hmm?
Can you repeat what you just said?
As long as you're talking about, I relied on these statements to form my opinion that he has mild schizophrenia.
Here's my opinion. In reaching my opinion, I considered statements made by the defendant's parents. I read the defendant's medical records. I read the police report. You haven't described what's in any of those things. That's okay. But when you start saying, and here's what I read, here's what the parents said, here's what the police report said, then you have a problem. Because now you're not just saying, I relied on things that experts in my field ordinarily rely on. You're trying to describe the content of those records or statements. One of those things is perfectly okay. The other may be objectionable.
Okay, thank you.
Right, do you want it? Sure. Right? But that cuts both ways, right? Dr. Loeb's not going to be able to say, well, I interviewed Mr. Green and Mr. Green told me this. Right? He's not going to be able to use those statements either. So you've got the arguments of both ways. Probably confrontation clause issues, I think. You know, if you start trying to get into specifics about what the parents actually told you, you know, our son Greens is a big old faker. Whenever he gets in trouble, he acts like he's crazy so he can garner sympathy to get away with his
He's been doing that
bad acts.
He's been doing that since he was 6 years old.
You know? All right. Marion is called by the prosecutor to testify in a bank robbery prosecution in which the defense is mistaken identity. Marion identifies the defendant as the person who ran past her as she walked towards the bank moments after it was robbed. Marion further testifies that she paid particularly close attention to the defendant because as she approached the bank, she heard an unidentified person call out from the bank doors, "The bank's been robbed. There goes the guy who did it," pointing at the running man. Assume that the prosecutor does not offer the unidentified person shout to prove that the running man robbed the bank, but instead to explain why Marion's identification is credible. Is Marion's testimony to the statement that she says led her to pay close attention to the defendant admissible over the defense attorney's confrontation clause objection? Trick question.
I'm sorry, who made the objection?
Defendant.
Okay.
Does the defendant have an opportunity to confront and cross-examine the declarant?
She's called to testify.
Marion's called to testify.
Right.
She heard, there goes the guy who robbed the bank. And the person points at that guy. And the prosecution says, I'm not offering that for the truth. I'm offering it because it helps explain why Mary Ann paid attention to the dude that was running away.
So since she pointed at the person running away, wouldn't that be an ongoing emergency, making it a non-testimonial statement?
Well, you can get into Crawford.
Oh,
I would argue,
Do you even have to get to
You
Crawford?
have to get to
there,
Crawford.
okay.
right? Is this even hearsay?
Oh,
And-
because of the pointing.
And if it's not hearsay,
Mhm.
does Crawford even apply?
No.
It doesn't. Right? But even assuming Crawford did apply, is this statement by the unknown declarant testimonial?
It's made to who?
The bank's been robbed. There goes the guy who did it.
And a non-authoritative person, so it's made to
What?
a non-authoritative person.
I'm sorry, what?
The unidentified person made the statement to Marion.
Yeah,
So it was.
who's she?
She's not.
She's a witness.
So you probably have multiple reasons why this doesn't come in.
Yeah, but
I mean,
don't-
why this
it does
would
come in.
probably come in.
But I agree with Professor Nolan. You're not even getting to Crawford on this. Because based on the way it's described, the only reason it's being offered is to explain why she was eagle-eyed and remembers the details of the dude that was running away. With dye pack on it.
One more, we got one more here.
This is gonna be the really good.
You should remember this one. Sandy Dungo is charged with murder by strangulation. Prosecution contends that Dungo killed the victim, Lou Pina, as part of a turf war between members of rival gangs. Dungo admits that he killed Pina, but claims that Pina's insult about Dungo's girlfriend provoked Dungo into a sudden response that at most constitutes voluntary manslaughter. Consider the admissibility of the following two items of prosecution expert testimony over Dungo's confrontation clause objections. The prosecution calls a pathologist, Dr. Lawrence, to testify that Pina was strangled to death and that the injuries to Pina's neck muscles indicate that Dungo strangled Pina for at least 2 minutes. Dr. Lawrence was not involved in the autopsy of Pina, but bases his conclusions on the autopsy report prepared by Dr. Belvick. Dr. Belvick performed the autopsy, but the prosecutor does not call Dr. Belvick to testify. Dr. Lawrence refers to Dr. Belvick's autopsy report while testifying, but the prosecutor argues that no confrontation clause violation occurs because the report was not offered into evidence and the statements in the report were not offered into evidence for the truth, but only as the basis for Dr. Lawrence's opinions. Can you call another pathologist to testify about cause of death and other things surrounding the manner of death? You're shaking your head, yes.
Why not?
And what's the deciding factor?
Recall.
Hmm?
They call for it?
Well, they're gonna be qualified, of course. The deciding factor is easy, guys. You gotta know this when we're talking about expert like analysis. If you're calling an expert to testify and he is giving his own opinion, he can rely on other people's work to form their opinion. Okay? If Dr. Lawrence was only testifying, well, Dr. Baldock opined that this is what happened, can't do that. He can't come in and give you Dr. Baldock's opinion. But as long as they're giving their own opinion, they can rely on other people's work to do that. Okay? The prosecutor also calls police officer Luis Fuentes to support the contention that Dungo killed Pina intentionally as part of a gang turf war. Officer Fuentes, who's qualified as a gang expert, testified that Dungo was a gang member who killed Pina for the benefit of Dungo's gang. Officer Fuentes based this opinion in part on casual, unrecorded conversations that he had with various members of both gangs in the days preceding Pina's death. Dungo objects that the gang member statements were testimonial and that because none of them testified, Officer Fuentes' conclusions are inadmissible under the Confrontation Clause. We talked about gang expert rules.
It says there were casual conversations. So.
The key to analyzing experts is looking at it through the expert's eyes, not necessarily through the immediately Crawford's eyes, right? When we're talking about lab results and are you calling the lab person when you're talking about opinions that they gave, are they their own opinions? When you're talking about gang experts,
Skills lay.
well, it's an expert opinion, right? But what do they get to do? He can tell you, here's my opinion,
This is what
and
I
here's what I'm basing it on. I talked to all these gang members. Who are they? I talked to this guy and this guy and this gal and this gal and this guy and that guy and that guy. And based on those conversations, here's my opinion. As soon as he starts saying, well, this person told me this, then you start getting into trouble. Okay? Can you get into those? In some situations. Right? But generally, the specifics of the statements, and this doesn't even give you the specifics of the statements, are fine. I mean, the fact that you had the conversations are fine.
And like we were talking about a couple questions ago, if all you do is say, I reviewed this record, I reviewed this record, I reviewed this record, I reviewed infield contact cards where police officers filled out a record of their conversation, whatever. But don't describe what the content is, I base my opinion on that, and here's my opinion. You're okay. But where you try to introduce, well, Officer so-and-so talked with Hal Hopp on the night of March 5th, and here's what Hopp said about the rolling 60s whatevers on the south side of Indio, then you have a problem. But if all you say is, I reviewed the record of this communication, this infield, whatever, you're okay. Does everybody see the difference between those two things?
And if you really want that statement in, then you call that witness. Right? Otherwise, it's just something your expert relied on, informing their opinion.
In cross-examination, the other side can ask all they want to about the content of those communications, right? And test the strength of the opinion or the basis of the opinion. Because who's going to do that cross-examination? The defense. And the prosecution doesn't have a Crawford right, right? It's like, and this is experts on direct examination can say, I consulted 3 of these learned treatises, right? To in forming my opinion. and I think that book's authoritative, and this one and this one. You don't get to say what the experts that wrote those books said, but you can say that you consulted them. On cross-examination, the defense lawyer can pick up the book and say, well, on page 433, Professor so-and-so said X, and that's not what you said, right? Right. Oh, shit. Okay. On direct, you don't get to bolster your opinion, your expert's opinion, by saying 40 other dudes that wrote books agree with you, right? On cross-examination, however, if you admitted something's authoritative, then you get to ask a whole bunch of questions about what that authoritative source says that undermines the opinion. Everybody see the difference between what you can do on direct and what you can do on cross? Okay.
All right, guys, Crawford questions?
So it's not testimonial if the expert testifies about his own opinion, generic.
If he's testifying about his opinions, it could be testimonial, but you're cross-examining the guy, the person who's making the declaration. Here's my opinion.
Right.
So you are cross-examining the witness, the declarant.
Oh, I got you. This is a cross-exam thing. Okay.
Or you're directed, you are examining the witness who's offering his or her opinion. So the other side gets to cross-examine that witness. Really? Is that your opinion? Well, what about this? What about this? What about this? Would that change your opinion? Yeah, right? But what you don't get to do on direct examination is talk about things that other people said. You can say, I relied on, I reviewed the deposition transcript or the witness statement of so-and-so. I reviewed the other witness statement of so-and-so. I reviewed these medical records from, Eisenhower or whatever. Great. That's what I base my opinion on. But you don't get to describe the content of those things.
Now you guys are all thinking, man, I thought here's going to be a piece of cake. It's a lot to the analysis, but if you follow your steps, step one, is it a criminal or civil case? Do I need Crawford, yes or no? Right? And if it's a civil case, inside you, yes. And then you.
Or if it's the defense presenting evidence in a criminal case, do we care about Crawford? No.
So, know the analysis, and then just follow your steps. Hit them all, score all those points.
And do not forget 403. Always, always, always 403, because a lot of times you can get through all this analysis and it's way more prejudicial than probative.
I was telling him, I talked to you guys last week about Crawford, and I just had this look on your faces. He's seeing the same look right now. He's like, oh, I know what you're talking about.
Okay, but I think we made a lot of progress today. I know he's saturated.
Next week is review week.
So come with your questions.
We're
Right?
gonna
Go
go
back
through.
over everything we've covered. We're going to talk about that essay from Saturday. Okay? And we'll talk about anything else you guys want to talk about.
Okay, that's it. Wow. It's 9 o'clock already. Now they don't tease us when we leave. Oh, they're leaving early, huh?
Yeah. All right, see you guys next week.
Yeah.
Glad to be back with you guys.
Wasn't it much funner than just me and my stale jokes?
Oh.
I still do it much.
I'm gonna keep using them, but.